Yes.
May it please, Lordship. Lordship, I make no mention for listing of a bail application, Lordship. The matter may kindly come up on Monday.
When have you filed?
Today, Lordship.
Then why are you mentioning?
Lordship.
It will be otherwise automatically listed within 2 days.
Lordship. And Tuesday, Lordship.
It will be otherwise listed by Tuesday.
Much obliged.
Wait, please, my lord. Prayer for withdrawal of a matter for Monday, my lord.
Okay.
Deeply obliged.
May I please? My lord, one bail application was filed in the January, my lord. In the February 4th, my lord, the medical report called from the Nagaon Central because, my lord, the person while commit
What you
suffering
want?
from, my lord, heart attack, my lord.
What do you want?
My lord, listing, my lord.
When?
My lord, on 18 or 19, my lord.
Okay, 19.
Please, your lordship. Lordship, I am seeking a lordship indulgence to list the matter on Monday, my lord.
When have you filed?
Yesterday we have filed.
Monday it will be otherwise listed.
Tuesday, my lord.
No, there is no requirement of mentioning. If it does not get listed within 2 days, only then you should mention.
Right.
Tuesday.
May it please, Lordship. My lord, I beg to mention for listing of one criminal petition. It was last listed on 2nd of May 2025.
When do you want?
19th, my lord.
Okay.
Next Friday. Much.
I beg to mention for listing of a criminal petition with your lordship. It was left over on 5th of this month, your lord. On Monday,
In what stage?
my lord, admission, because NBW has been issued and the next date is on 18 in the trial court.
When is the next date?
18 of this
Okay.
Monday.
Okay.
Lordship, similar prayer on 16.
What similar prayer?
Criminal petition listing. Your lordship.
What is the urgency?
Urgency, your lordship, NBW issue, but that in trial court on 3rd 7 fixed, your lordship. So there is an urgency.
Tuesday.
I'm so obliged.
May I please, your lordship, I have mentioned one item CRPIO for listing of today's list, but due to some defective, it was not listed today.
CRPI we have to mention before. Court number?
Yesterday it was allowed here only.
No, today there is a separate court earmark. Justice Long Kumar's court.
20.
Yes.
Sir, a listing of urgent application on Monday.
What application?
My lord, bail application on Monday.
When have you filed?
I filed, my lord. Because he's a cancer patient.
Okay.
May I please, Lordship. Lordship, I beg to mention item number 19. The arguing counsel for the petitioner is out of station. My lord, may kindly fix next week, any date.
What is your name?
H. Nath.
Heard Mr. H. Item number 19.
Yes, sir.
Heard Mr. H. Nag, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the conducting counsel. Prayer is allowed. Let this matter be listed 19th.
I wish to mention for listing one IA on Monday. It was filed on.
Regarding what matter?
Regarding, I have filed a criminal petition. People challenging the proceeding of trial court. That was staged by this honorable.
Date.
In the meantime, my lord, he was arrested.
17th.
He was arrested, my lord, on the state of NBW. But trial court proceeding has been stayed by this honorable subsequently.
15 Monday.
Always.
May I please your lordship? Lordship, I beg to mention item number 37. Lordship, kindly matter may be adjourned for 2 weeks.
Why?
Yes, I'll state something, lordship.
Yeah, sheet submitted. Item number 37.
Yes, lordship.
Will pass orders when the matter is called. Wait for your turn. Wait for your turn. Yes, next.
This lordship, I beg to mention for listing heavy law. Lordship, last occasion, court was not seen.
When have you filed?
Lordship, I was filed the 29th January, lordship. Last occasion, my lord.
Yes.
court-
Putul. 22nd.
Main piece of Lordship, I beg to mention for listing of two anticipatory appeals on Monday, Lordship.
When have you filed?
Lordship, one we have filed yesterday, one we have filed today, Lordship. But Lordship, only thing is that they have received notice for appearance for Monday, Lordship. There is some urgency, Lordship.
Okay.
With your obligement.
May I please, Your Lordship? I beg to mention item number 14, Lordship. And the adjourn for that.
40.
1-4, Lordship. It's a motion for it.
Heard Miss Ine Begum, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty. Prayer is allowed. Let this matter be listed on 15th of. It will obviously come in motion. 15th.
Wait, please, Your Lordship. Lordship, I beg to mention for listing one of criminal revision petition for admission, Lordship. Lordship, matter may be listed next week, any date, Lordship.
22nd.
Stop.
Beg to mention for listing of criminal petition for orders. I'm making it with us.
19th.
May please, Your Lordship, I am preparing for listing one criminal petition, madam, on 17, my lord.
18th.
Obligement.
I beg to mention for listing a bail petition for withdrawal unit on Monday.
Okay.
Blank.
Lordship, I beg to mention one interlocutory application filed in criminal appeal, Your Lordship. It was last listed on February, Your Lordship, thereafter. On Wednesday, Your Lordship.
17th.
Much obliged.
Please, Your Lord. I pray for listing of the CRPIO, my lord.
CRPIO, code number 20.
20.
Code number 20. Yes.
Lordship, like to mention two criminal petition for admission, Lordship. In the month of May, it got left over, Lordship. Next week, if
22nd.
obliged.
Please, Your Lordship. I beg to mention for listing of an RSA, my lord.
20. Code number 20.
May it please your lordship, I beg to mention criminal petition lordship listing
For what?
for NBW issue against the petitioner lordship.
What is your prayer?
Lordship, can it be on 17 lordship? Kindly fix this matter.
Okay.
Obliged lordship.
I beg to mention one matter, my lord, the criminal revision. This case was last listed on 16/9/2024. So it may be listed in any date.
24th June.
My pleasure. Well, I beg to mention for listing on AB, my lord. It was last listed on 3rd June, my lord. On that day, my lord, respective bench was not seated. So, my lord, kindly Monday, my lord.
17th.
17, my lord, Monday, proceed.
17th.
I'm on that.
The date for listing upon criminal appeal, although it is fixed for hearing, my lord, on the last occasion it has not reached, and my lord, the petitioner already spent 3 years in jail, sentences of 5 years, my lord. Next weekend,
Hearing you pray before registry. Pray before registry.
May I please your lordship, I beg to mention item number 50, your lordship, supplementary list. Lordship, in this matter, steps need to be taken, your lordship. So kindly the matter may be adjourned.
What steps?
That justice service has to be served to the respondent of.
On request of. What is your name?
D. Upreti.
B.
D. Upreti.
And on request of Mr. D. Upreti, learned counsel for the petitioner, some more time is granted to take necessary steps for issuance of notice
So can it
on
be
the respondents by Dusty Mode. Let this matter be listed on 24th of June.
like your lordship?
Mention for listing order on criminal petition.
22nd.
I beg to mention criminal petition number 100/2024.
Or
That was last listed on 5/2/24.
yes. 22nd. 22nd June.
Look, the matter was stayed since long.
22nd June.
Might be before
22nd June.
I will be allowed to withdraw this
And
petition
Ms.
and
B.
revert
Gogoi.
it, file a fresh one.
Learned counsel for the petitioner who prays for allowing the petitioner to withdraw this instant anticipatory bail application. Liberty is not required. You can always come whenever there is an apprehension. With the liberty to file a fresh anticipatory bail application is required. The prayer is allowed. This bail application is dismissed on withdrawal with the liberty sought for granting.
Item 2. Yeah, please.
Heard Mr. S. Islam, learned counsel for the petitioner who prays for allowing the petitioner to withdraw the instant anticipatory bail application. Prayer is allowed. This anticipatory bail application is dismissed on withdrawal.
Item 3.
Pass over for time being, Lordship.
No passing over.
Suspect case for POCSO is there.
Wait, what is your name? Heard Miss R. Deka.
S. Nazneen.
S. Nazneen, learned counsel for the petitioner. Also heard Mr. B. Sharma. Sorry, sir. D.P. Goswami, learned additional public prosecutor. Let the notice be issued to respondent number 2. Charge sheeted case. Let the scanned copy of the trial court records along with the scanned copy of the connected case diary be called for. The petitioner shall take steps for issuance of notice upon respondent number 2 in pursuant to the prevailing notification of registry in this regard within 7 days from the date of this order, returnable on 17th of July.
Sorted may be given, Lordship.
Before vacation due.
Before vacation.
25th June.
Against.
4.
May please, your lordship, the FIR face lordship 13 lordships.
What is the case?
The lordship, on the day lordship, the 28th is the Eid Udh lordship. On that day, the cattle was lordship processing. Lordship, that the case is lordship. In the meantime, the police has lost FIR and the petitioner was arrested, lordship.
91 kg of suspected cattle meat was.
Where is the rejection order? Try
Lordship.
the rejection order. You have
Rejection order is not available, lordship.
heard Mr. N. Ahmed, learned counsel for the petitioner. Call for the case diary. Let this matter be listed.
22nd.
22nd June.
Item 5.
Lordship 20.
22nd June.
22nd.
Next item.
May I please, the lordship? My lord, matters relates to the recovery of ganja, not from the present petitioner, my lord, from a different place. And it is 6 kgs of ganja, my lord, intermediate quantity. The petitioner.
Where is the rejection order?
My lord, rejection order is not.
You have not approached the.
My lord, once they have approached, my lord, but I have not annexed the.
That is requirement. If you have approached any other court earlier, the rejection order has to. That is the requirement of the notification.
My lord.
It is pending investigation.
My lord, 40 days in custody, my lord.
Okay, they will call for this.
You also annex the rejection order. Heard Mr. S.A. Hussain.
My lord, DJ Halloween.
DJ Halloween, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor. Let the case diary be called for.
23rd of June.
3rd of how much? Which date?
23.
Let the matter be listed on 23rd of June.
Okay.
Hello.
Item 6.
May it please your lordship. Lordship, I have been arrested under section 21C and 29 of the NDPS Act.
Pending investigation.
The charge sheet has been filed, your lordship, and I am in jail since the last 183 days.
What is your ground?
Ground is that though the notice under section 48 has been given to me, but it was given in a very technical manner. The reasons and the grounds which has to be depicted in a manner as the stated by the Honorable Supreme Court.
And Mr. G.R. Datta, learned counsel for the petitioner, also Mr. D.P. Goswami, learned additional public prosecutor. Charge sheet has been laid.
Yes, your lordship. 28 February 26.
Let the scanned copy of the trial court records as well as scanned copy of the connected case diary be called for. Registry to take steps for requisitioning the scanned copies. Let this matter be listed. 17th of July.
7.
Item 7.
Deeply closed.
May I please your lordship? 483 application, my lord. FIR is at page, my lord, 13, my lord. The girl was missing, my lord, while she was returning from the school, my lord. And thereafter she was recovered, and father has lost this FIR without mentioning anything. But later, my lord, on investigation, the petitioner was arrested, my lord. 36 has not been complied. 48 has been given to some other person, not my father. He is no longer my relation. And my lord, interestingly, my lord, I take your lordship the rejection order page 30 by the learned additional session judge. He has incorporated his lordship, he has learned additional session judge incorporated different story, different case in my rejection order. Annexure 7, page 30, my lord.
Page 13.
My lord, my case is something, the case in brief is that on 24/7/25, the complainant lodged an adjournment alleging inter alia that about 10-11 months prior to that, in the year 2024, his daughter, namely Sanjana Das, about 16 years and a student of higher secondary second year, had developed a love relation with one Amrit Singh. It is alleged that the accused, on the false promise of the marriage, had taken the girl away from her college to his sister's house, but sindoor on her forehead and made her believe that they were married. It is further alleged that the accused thereafter established physical relation with the victim. Subsequently,
We are issuing notice.
something different story, different case, not my case. My case, HR and forwarding will reveal everything, my lord. My forwarding, I take your lordship, page 17, my lord. Page 17. And it is Silchar PS case of 219/26. The accused forcefully and physical relation with the victim girl who was 16 years old. That is a different girl.
Maybe. But two. The petitioner shall take steps for issuance of notice upon respondent number 2 in person to the prevailing notification of the registry in this regard within 7 days from the date of this order, returnable on 17 July.
July. My lord,
Before vacation.
within this month, it is possible, my lord.
25th June.
25th June. My lord,
Let the case diary.
Who is to be made party? Notice my case. I will kindly pass that order. Issue notice to respondent 2.
I have already dictated that.
Obliged, man.
He should call for the case diary also.
What is it?
Item 8.
No, it is also 483. My lord, I am the owner of the hotel. I do business in Manipur. It is being run by the manager. My lord, what happened? The accused took shelter into the hotel with the informant's daughter. And my lord, later they were recovered from this, and a case has been registered against the hotel manager and the lady who has brought this, who accompanied the victim girl, and now they are under, I am for the owner of the hotel, my lord. Now, hotel, is it possible? Possible, my lord. 19th.
On 19, you will get another date after vacation.
My lord, I will be busy from, in fact, from 22. I pray before your lordship, if possible, because it is, the whole detention is illegal, my lord.
19th. Okay.
Item 9. I just stable.
May I please, Your Honor? It's a regular bail application, Lordship. NDPS commercial quantity is there, Lordship.
But this name Begum, learned counsel for the pending investigation or charge sheet has been laid. What is the status?
No idea, Lordship.
You have no idea.
There is no. Search list is not submitted, Lordship. 48 days detention, Lordship.
Yes, Miss Devi. Yes.
It's a commercial quantity.
It is pending investigation.
Yes.
Final complaint has been filed.
Yes, from the petition option.
So what is your submission?
Let it be put up after 2 weeks in the meantime. If they have to file their complaint. And if there is any material lordship, I'll basically.
Also, Mr.
I'm R.K. Chaudhary, lordship.
R.K. Dev Chaudhary, London, Deputy Solicitor General of India, who prays for some time to file written objection if necessary after taking instructions. The prayer is allowed. Let this matter be listed. 15th of July.
Of license.
Item 10.
May it please your lordship. May it please your lordship. Here, my lordship may call for the case that is facing a short date next week, possibly, my lord.
And Mr. What is the case?
The case is, my lord, some goods were recovered from my vehicle, my lord, allegedly to be stolen, my lord. It is.
Heard Mr. S.M. Abdullah P. Learned Counsel for the petitioners. Also heard Mr. D.P. Goswami, Learned Additional Public Prosecutor. Let the case diary be called for. Let this case be listed on 22nd June.
Oblige, your lordship.
Item 11.
Yeah, am I not 11? May it please your lordship. Here, my lord, page 10 is the FIR, my lord. Whatever, my lord, 11 numbers of cattle were recovered from my vehicle, my lord. The which are allegedly suspected to be stolen cattle, my lord. Okay, to DT person. So already the owner of the cattle were granted interim pre-arrest bail, my lord, by a coordinate bench of this honorable court, my lord. Now, my lord, I am the owner of the vehicle, my lord.
Where is
Page 10.
the affair?
FIR at page 10.
Yes, Mr. Goswami.
My lord, already the owner of the cattle were granted pre-arrest bail, interim pre-arrest bail yesterday, my lord.
When is the
11
case?
cattle were recovered.
When is the next date?
The next date, my lord, I'm sorry, I've given the order, my lord.
Heard Mr. S.M. Abdullah P. Learned Counsel for the petitioner. This application under section 482 of BNSS 2023 has been filed by the petitioner, namely Hanif Ali, who is apprehending his arrest in connection with Ajo PS case number 223/2026. Sorry. under section 303 within bracket 2/3 within bracket 5 of BNS, read with section 13 within bracket 1 of Cattle Preservation Act 2021 and section 11 within bracket 1 within bracket small d of Prevention of Cruelty to Animals Act 1960. The gist of accusation in this case is that on which date, on 4/6/2026, one Shri Dhruvo Medhi had lodged an FIR before the officer in charge of Dadara police outpost, inter alia alleging that on that day at about 3 p.m., one vehicle bearing registration number AA01QC6402 was intercepted by the patrolling party of Dadara police outpost, and in the said vehicle 11 numbers of cattle were recovered which are suspected to be stolen cattle. Stop. Learned counsel for the petitioner submits that the petitioner is the registered owner of the vehicle in which the cattle were being transported. He submits that the said cattle are not stolen cattle, but belongs to one Ali Akbar, who is also one of the co-accused in this case. He submits that the owner of the cattle which were recovered from the vehicle of the present petitioner has already been granted interim anticipatory bail by a coordinate bench of this court on 11/6/2026 in AB case number 1246/2026, and next date of the case is fixed on 27/2026. So, considering the submissions, let the case diary of the Hajo PS case number 223/2026 be called for, and let this case be listed along with AB case number 1246/2026 on 27/2026. Stop. In the meanwhile, the petitioner is directed to appear before the investigating officer of the Hajo PS case number 223/2026 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so, in the event of his arrest in connection with the aforesaid case, he shall be granted interim anticipatory bail of rupees 25,000 with a surety of like amount to the satisfaction of the arresting authority, subject to the condition that the petitioner shall cooperate in the investigation. Stop. List accordingly on 27/2026.
Oh, Blackman.
Item 12.
May it please your lordship. Here, my lord, for one offense, 3 FIR lodged and police also registered 3 cases. I have annexed all 3 FIR
ABC, that is, my lord, Uriamghat PS case number 8, Uriamghat PS case number 9, and Uriamghat PS case number 10. Here, before your lordship, is the 10, my lord.
What is the offense?
Offense, my lord, illegal mining, my lord, that is Rengma Reserve Forest, Uriamghat. That is the allegation, my lord. Here in the FIR, my lord, nobody named. I am also not named. I afraid of my arrest, my lord, because in other FIR, my name shown, my lord. Here, this case, my lord, my name not shown. Nobody is named here. One FIR lost by the Forest Department.
Where is the FIR?
FIR page 9, my lord. May I read, lordship?
No.
Uh,
No.
Yes, yes.
What happened to the other two?
Other two, my lord, in one case, my lord, a coordinate bench allowed, my lord, interim.
Yes, Mr. Goswami. Heard Mr. B.B. Gogoi. Mr. Goswami, you have anything to?
Page 23, that Office of the Range Forest Officer, Uriamghat Range, lordship. Only thing I have pointed out, lordship, the persons involved in an next 24, lordship, persons involved in an unauthorized activities, the petitioner's name is here, number 11.
No, that is a different affair.
Lordship.
That is, 3 authority lost 3 FIR. One Forest Department, another Social Forestry, another one, my lord, by the Sutia Satra Hongothan.
Heard Mr. B.B. Gogoi, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor. This application under Section 482 of BNSS 2023 has been filed by the petitioner, namely Pawan Kumar Agarwala, who is apprehending his arrest in connection with Uriamghat PS case number 10/2026 under Section 324 within bracket 5/329 within bracket 3 of BNS 2023, read with Section 26 of the Indian Forest Act 1927 and Section 3 within bracket 1 of Prevention of Damage to Public Property Act 1984. The gist of accusation in this case is that on 1/5/2026, the Divisional Forest Officer, Social Forestry Division, Golaghat, had lodged an FIR alleging destruction of plantation at Sonarbil area under the Rengma Reserve Forest, Uriamghat. Stop. Learned counsel for the petitioner has submitted that though the petitioner has not been specifically named in the said FIR, however, in respect alleging similar facts, two other FIRs have also been filed by different persons, and in other FIRs, name of the present petitioner was mentioned. Learned counsel for the petitioner submits that in a case registered on the basis of one another FIR, the petitioner has already been granted interim anticipated bail by a coordinate bench of this court in AB case number 1227/2026 by order dated 10/6/2026. He submits that the petitioner is ready to cooperate in the investigation. Stop. I have considered the materials available on record and as well as submissions made by learned counsel for both sides. Let the case diary be called for. Let this matter be listed again on 17/7/2026. In the meanwhile, considering the facts and circumstances of this case, the petitioner, namely Pawan Kumar Agarwala, is directed to appear before the investigating officer of Uriamghat PS case number 10/2026 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so, in the event of his arrest in connection with the aforesaid case, he shall be granted interim bail by the arresting authority on furnishing a bond of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, subject to also condition that the petitioner shall cooperate in the investigation. Let this matter be listed accordingly on 17/7/2026.
Item 13. Here, my lord, another affair 13 is that is filed by the Forest Department, my lord. Uriamghat PS case number 9.
Heard Mr. B.B. Gogoi, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Pawan Kumar Agarwala, apprehending his arrest in Uriamghat PS case number 9/2026 under section 305 within bracket E/324 within bracket 5/221/351 within bracket 2/61 of BNS, read with section 25 within bracket 1 capital A of Arms Act and section 26 of the Arms Act is also there.
That is there, my lord, to make it, my lord, serious. They added.
Then
Otherwise, my lord.
Then we have to go through the case diary.
No, my lord, what's happened, my lord? Your lordship, please turn to page 15. Page 15. I am a businessman, my lord. I have valid license. I am operating at Nagaland, my lord, not here in Assam. This case is registered at Assam, my lord.
Valid what license? Gun license?
This is, no, not gun, my lord. This is a stone crusher. I am doing this stone business, my lord. That is.
We'll call for the case diary. Only after that, we'll fix a short date.
Otherwise, my lord, he cannot appear in other cases, my lord. Other two cases already, your entering is there, my lord.
Where is the affair? Where is the?
Yes, affair is 10.
Why Arms Act comes?
But not mention anything, only that some extremists harassing. That is not specifically mentioned that he has used arms and threatened. That is not there in the FIR also. Only one line that is there, my lord. However, on notice the presence of official, the persons involved moved towards the Nagaland side and from there reportedly issued threats with arms and create objection to government official in discharge their duties. So who has obstruct, my lord? Who has shown gun? That is not clear. I am not that type of man, my lord. I am doing business, my lord, only. It is not the case of extortion or like that, my lord.
The gist of accusation in this case is that one Hiralal Paul, range forest officer of Ghat range, had lodged an FIR, inter alia, alleging that during field visit by the forest officials, it came to their notice that there is illegal stone extraction using heavy machinery during night hours. And when the Ghat forest official who conduct patrolling in the said area tried to prevent such activities, the person involved allegedly moved towards Nagaland side, and from there they used to issue threats with arms and create obstruction of government officials. Obstruction to the government officials in discharge of their duties. Stop. Learned counsel for the petitioner has submitted that petitioner is a businessman. Where do you do your?
That is, my lord, Nagaland, my lord, Ukha district. That is page 15, my lord. Oro village, Ukha district, my lord. That is the permit, license, state license. Another is no objection certificate from
He's a
head of the
businessman and not involved in the offense alleged in the FIR. He submits that no specific accusation has been made against the present petitioner in the FIR. He also submits that the petitioner is ready to cooperate in the investigation. Let the case diary be called for. Let this case be listed on after 17 July. In the meanwhile, considering the submissions made by learned counsel for the petitioner as well as material available on record, the above named petitioner is directed to appear before the investigating officer of Ghat PS case number 9/2026 and cooperate in the investigation. Stop. If he does so, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount to the satisfaction of the arresting authority with following conditions, 2 conditions. List accordingly on
17.
Because arms act, their allegations is serious.
Bill ऊपर देना. Mr. D.P. Goswami, the learned additional public prosecutor, raised his objection to grant of any interim protection at this stage, considering the involvement of offense under Arms Act in this case.
Item 15.
Yes.
May it please your lordship. My lord, page 10 is the FIR, my lord. Whatever, my lord, the allegation is basically against one Mintu Ali, my lord. Page 10 is the FIR, my lord. Now they have roped in the whole family, including a person who is in the other world, who expired way back, my lord. His name has also been inserted, my lord. Page 10 is the affair. Main allegation, not in first page, my name does not reflect, my lord. In the second page, my lord. In the
Where is the original affair?
Original affair, my lord. Page 18, my lord. This small, my lord. That's why we have typed it. The letters are small.
What is your name?
My name is, my lord, Rohan Ali, my lord. Rohan Ali. My name does not reflect in the first page, my lord. First page, my lord, allegation, the person who has done that, my lord, is Abdul Mintu Ali, my lord.
Read the affair.
My lord, with all due respect, I have the honor to inform you that Ijaz Ahmed, son of so-and-so, resident of so-and-so, Dibrugarh, Assam, my younger brother Abid Ahmed, today on 11/4/2026 at about 10:30 a.m. was going to shop for purchasing household items. Then suddenly, Abdul Mintu Ali, number two Rinku Ali, both is sons of late Babujan Ali, Sonu Ali, and Alfaz Ali, started firing with pistol, revolver, but Abdul Mintu Ali directly hit on my younger brother Abid Ali, due to which one bullet got hit on the left. It should be eye, my lord. Eye of my younger brother, and my brother fell down on the earth and became unconscious. That's during the incident, one Imanuddin Ahmed, son of so-and-so, was present at the place of occurrence, and he tried to save my younger brother. And as such, the above named culprits also fired upon him, but somehow he ran and entered in a boundary of my nearby house. And from there itself, he shouted and called my father. That, sir. Thereafter, me and my father came on the spot and showed that all the above named accused person, along with Neha Begum, wife of Abdul Mintu Ali, Irfan Ali, Adil Ali, Sonu Ali, Bitu Mura, Nipul Gogoi, and Rohan Ali, Nono Ali, and other unknown persons started beating my younger brother with hand and fist. When he, here is the allegation, Rohan Ali, my lord. When me and my father tried to save
Who is that person?
my Sonu Ali, I have annexed it, my lord, death certificate, my lord. Page 24, my lord. And page 24 is his death certificate. He has expired on 2025, my lord. So, well, possibly, maybe there may be some allegation against Abdul Mintu Ali, my lord, but other family members are just roped in, my lord. They and my lord,
Read remaining part.
yes, my lord. To save my brother named Abdul Mintu Ali, and also fired on us, but somehow escaped from their bullet. Thereafter, some people of locality, along with me and my father, and Imanuddin Ahmed, took my younger brother to Gogoru Pothar police station, Dibrugarh, but by auto, and thereafter admitted him in AMKS, where his condition is very critical. That, sir, the above named all persons are very dangerous and also involved in several criminal acts, and also history sheeter of locality.
The incident occurred on 11/4.
Yes, madam.
Since then, you are not arrested.
But Mother Rohan Ali, Malad, Rohan Ali, the Lottery may kindly see, there is no specific allegation against Rohan Ali, Malad. Because we have also lost that FIR against them, Malad, but it was not traceable. It was received by, accordingly, duty received by the concerned police station, Malad. And Malad, they have roped in the after family members, Malad. Lottery may kindly turn to page 24.
No, why have you come now? In the month of June.
But because we are, my lord, because police has started searching us now, my lord, and my lord, the lordship may kindly say, we have also lost an FIR against them, my lord. That is at page 19, my lord. It was duly received, my lord, but not registered, my lord. And my lord, they have lost and roped the dead person also, my lord. who expired in 2025. We have categorically stated, and moreover, my lord, yesterday, my lord, a matter came up before a coordinate bench of this honorable court, my lord. Interim bail was granted that wife of Mintu Ali, my lord. We did get an order to. Of course, that was bail application, my lord, but interim bail was granted.
Neha Begum.
Neha Begum, my lord.
Neha has been arrested.
Yes, but interim bail was granted. Yes, my lord. And bail application, because there are no specific allegation against Abdul Mintu Ali, my lord.
Yes, Mr. Goswami.
And they have, these, I can understand, my lord, some quarrel there, but my lord, the whole family has been roped in, my lord. Even the dead persons who expired, my lord, their name has also been inserted in the affair.
Yes, Mr. Goswami.
Yeah, Lordship, but otherwise, Lordship, allegations are serious and perhaps here the FIR specifically named in the petitioner.
Regarding my allegation, there is no arms act, my lord. Only my panses, my lord, and my lord, this thing, my lord. Allegation. That too, one Sonu Ali was also there who expired in 2025.
But this allegation made by the FIR, so I take a case they only.
We'll fix a short date.
Lordship, may kindly see, my lord, because my lord,
No, till now, for last 2 months, there was no FIR.
But police started searching me now, my lord.
Where is the statement?
We have categorically stated, my lord, that my lord, police.
We'll fix a short date. Where is the statement?
Paragraph 7, my lord, investigation came in search of the petitioner, but fortunately.
When?
Date we have not written, my lord, but
for last 2 months you were not arrested.
But my here, my lordship, from the face of the affair, it reflects, my lord, there is no specific allegation against them regarding arms act. A dead person has also been named in the affair.
We are giving a very short date.
But from Dibrugarh,
how much time will you take?
22nd.
From Dibrugarh, it won't. The lordship may kindly grant some interim protection. Will appear, my lord, because there is only the out of Braj, my lord.
Heard Mr. S.M. Abdullah P. Learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner Rohan Ali, who is apprehending his arrest in connection with Dibrugarh PS case number 103/2026 under section 122 within bracket 2/109 within bracket 2/3 within bracket 5 of the BNS, read with section 25 within bracket 1 capital A of the Arms Act. The gist of accusation in this case is that on 11/4/2026, one Izaz Ahmed had lodged an affair before the officer in charge of Dibrugarh police station, inter alia, alleging that on 11/4/2026 at about 10:30 a.m. when the first informant's younger brother, namely Abid Ali, was going to shop for purchasing some household item. Suddenly, one Abdul Mintu Ali, Rinku Ali, Sonu Ali and Alfaz Ali started firing at him with pistol/revolver. As a result of which, the younger brother of the first informant sustained injuries on his left eye. It is further alleged in the FIR that later on some other persons, including the present petitioner, assaulted the first informant and his father when they reached at that place. Stop. Learned counsel for the petitioner has submitted that the allegations made in the FIR against the petitioner are not true. Are the main allegations of firing and injuring the brother of the first informant is against Abdul Mintu Ali, Sonu Ali, Alfaz Ali, and Rinku Ali. And name of the present petitioner has been inserted in the FIR only to implicate them. He submits that even one dead person, namely Sonu Ali, has also been made an accused in this case. He submits that the petitioner is ready to cooperate in the investigation. He also submits that no allegation of using any firearm by the present petitioner is there in the FIR. Stop. On the other hand, learned additional public prosecutor praised for calling the case diary, since the offense involved in this case is serious, is a serious offense. He also submits that no interim protection may be granted at this stage to the present petitioner. Stop. It appears that I have considered the submissions made by learned counsel for both sides. It appears that the incident occurred more than 2 months ago on 11/4/2026. However, the petitioner has not yet been apprehended. It also stop. Considering the facts of this case, perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary. Let this matter be listed after the 17th July. In the meanwhile, considering the submissions made by learned counsel for the petitioner as well as the materials available on record, the petitioner, namely Rohan Ali, is directed to appear before the investigating officer of Dibrugarh PS case number 103/2026 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions. 2 conditions.
Obliged, my lord. That case is fixed on 28/7, my lord.
Let this matter be listed on 28/7.
Along with BA number 1525.
Along with BA case number 1525
Oblique
of
26.
2026.
Obliged, my lord.
I did 48 form supplementary list.
May I please, this is a 480 application, Lordship. FIR lost by one police person. There is a quarrel between them, Lordship. Director, both sides lost a FIR against each other, Lordship. And turn page 9 is the FIR lordship, translated type copy lordship. Barnicola page 13 lordship.
Yes,
May I read lordship?
yes.
With due respect, a humble submission is that on 24/5/2020 Sunday at about 11:20 p.m. while I along with two other person was returning home after dropping female three Bihu performance of our Bihu group at their homes in Pehipukhuri. On the way, our vehicle broke down at Tiokghat. We tried to start the vehicle by pushing it but failed. Thereafter, we informed the Sarada police reserve and they told us that another vehicle would be sent to pick us up, and accordingly we remained there waiting. After some time, two persons of Tiokghat, namely Rupjoti Kolita, he was arrested, something like that, and Sri Hunkan Khaklari lordship. This is the petition number 1 lordship. Along with the other two other person arrived in a vehicle bearing registration number so Swift Desire. They abuse us with obscene language and misbehave with us. Moreover, they attack us with sharp weapon and attempt to kill us, and forcibly took away of rupees 10,000 which I was carrying in my hand. Seeing the situation deteriorated, we informed the IC of Rajapokhari. He arrived at the spot. Even after his arrival, the aforesaid group obstructed him from discharging his official duty, misbehaved with him, physically assault him, and tore and damaged his uniform. Another person bearing the surname Lahon also instigated and provoked him. Here in this case, the actual fact is the family turn is the page 15. This is the actual fact. This is what lost by the wife of the petition number 1, because the said informal lordship, their options remark towards the petition number 1 wife and their sister-in-law. Can this is the page 15? This married list. This one lost by the wife of the petition number 1. Married list. With their respect, I, Jolie Ramsey, wife of Deposit Khakle, is the petition number 1 lordship. Resident of Tiog Havir beg to state that on 24/5/2026 at about 11 p.m. my husband, our son, and I were traveling on one bike.
Case diary would be required.
No lordship. Lordship. Thereafter, one of the main accused lordship, Rupjoti, was arrested lordship. Thereafter, he will release on bail lordship. In the case diary, the injury is simple lordship. Can see. Hello. I have tick mark lordship. As during the course of investigation lordship, the reveal from the case IO record a statement of informant and two more persons who were present with him at the time of incident. As per the statement of informant, Jagat Forward.
Yes, Mr. Goswami. We'll call for the case diary.
Till that lordship, maybe interim lordship, that because petitioner also attacked by that. I have annexed that is 24 page is the injury photograph of injury of the petition number 1 lordship. That is the page, kindly see page 24. He was attacked by the present petition informant lordship. And as per CT scan report, there is a fracture, that is page 19 lordship. CD also revealed that medical report simple injury, but the present petition number 1 is a grievous injury. That is page 25 is a photograph. So the attack is for eye lordship. And as per CT scan report page 9 lordship, impression fracture in both the medial and lateral wall of the left orbit with associated with left orbit soft tissue, hemorrhagic chances and orbit high emphysema. That is page 19 lordship, impression lordship. This is a medical report of a CT scan report of Deposit Khaklari. This is a petition number 1. Therefore, the section lordship on the 296, the available option 118 not applicable in this case. The 109 also not applicable as per the CD lordship. The injury is simple lordship.
Heard, Mr. What
B
is the
Islam.
B Islam done with counsel for the petitioner. Also Mr. D.P. Goswami. Yes, Mr. Goswami, you have anything? D.P. Goswami, Learned Counsel, Learned Additional Public Prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioners, namely Debojit Khaklari alias Munkan Khaklari and Montu Lahon, who are apprehending their arrest in connection with Sonari PS case number 32/2026 under section 296/118 within bracket 2/109/309 within bracket 6/121 within bracket 2/324 within bracket 6/54 of BNS. The gist of acquisition in this case is that on 25/2/2026, one Jagat Barua, had lodged an FIR before the officer in charge of Sonari police station, inter alia, alleging that on 24/5/2026 at about 11:20 p.m. when the petitioners were coming back to where they were coming back
Lordship.
to their homes at Pehipukhuri, their vehicle broke down at Tiok Ghat stop. At that place, the present petitioners with one Rupjyoti Kalita. It is further alleged in that FIR that at Tiok Ghat, one Rupjyoti Kalita, petitioner number 1.
Not petition number no. Hunkan Kolita is a petition number. Deposit.
Rupjyoti Kalita and petitioner number 1 and 2 other persons misbehave with them and misbehave with the informant and attacked them with sharp weapon and took away 10,000 rupees from them and obstructed the informant, who is a police personnel, from discharging their official duties. Learned counsel for the petitioner has submitted that the allegations made against the petitioners in the FIR are not true. He submits that there was some tussle between the first informant and the present petitioners on that day, as the who is Joliram Sari?
Joliram is the wife of the petition number 1.
As the first informants and other police personnel hurled obscene remarks on to the sister in law of the petitioner number 1, who was going in her scooty at that point of time. He submitted that as a result of the said incident, some tussle was there between both sides. However, the accusation made against the petitioners in the FIR are not true. He further submitted that in the meanwhile, one of the main accused, namely Rupjyoti Kolita, was arrested. However, he was granted bail by the Court of London, Sessions Judge Saraidev, in bail application number 108/2026. Stop. Learned counsel for the petitioners further submits that while granting bail to the co-accused, it was observed by the Court of Learned Session Judge Saraidev, after perusal of the case diary, that the injuries sustained to the informant of the Dibrugarh Sonari PS case number 32/2026 is a simple injury. Stop. He further submits that since one of the main co-accused has already been granted bail, and since the petitioners are ready to cooperate in the investigation, they may be allowed to go on bail. On the other hand, Mr. D.P. Goswami, the additional public prosecutor, opposed the grant of bail at this stage and prays for calling of the case diary. Let the case diary be called for. Let this matter be listed on 17 July. However, in the meanwhile, considering the fact that one of the co-accused has already been granted bail by the Sessions Court, and also the fact that the petitioners are ready to cooperate in the investigation, the above named petitioners are directed to appear before the investigating officer of Sonari PS case number 32/2026 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If they do so within the stipulated period of time, in the event of their arrest in connection with the aforesaid case, they shall be allowed to go on interim bail of ₹30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions 1 and 2, list accordingly.
Item 16.
Yes, a report was called for, Lordship. We have not received that report, Lordship.
What report?
My lord, here, my lord, these are livestock, my lord. Cattle were seized, my lord. 8 numbers of cattle, my lord. The petition had produced the receipt, my lord. And now, my lord.
When will you produce the report?
Next week, Lordship.
Heard Mr. S. Hawk, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, an additional public prosecutor, who prays for some more time for producing the report from the officer in charge of Gosaigaon Police Station as directed by this court by its order dated 25/5/2026. Prayer is allowed. Let this matter be decided.
23-6.
23/6.
Please, Your Lordship. Lordship, the accused in this case is facing trial before the learned special judge Pokso Nogao. During the course of the trial, he pleaded juvenility, Lordship, and thereafter a medical examination report was called for. Lordship, may please first have the report at page 32, the last page of the petition.
Yes.
Lordship has page 32. The last paragraph. From the physical, radiological, and dental examination of the above mentioned individual, we are of the opinion that the age of the individual is between 17 and 19 years of age. Lordship, thereafter, this was wrongly appreciated by the learned trial court below at page 14. That is the impugned order, Lordship.
26. Passed by Court of Learned Special Judge within bracket Pokso Nogao in Special Pokso case number 40/2026, whereby the petitioner was not held to be a juvenile on the date of alleged offense. Stop. Let the scanned copy of the trial court record as well as the connected case diary be called for. Let also notice be issued to the respondent number 2. The petitioner shall take steps for issuance of notice in pursuant to the prevailing notification of the registry of this court in that regard within 7 days from the date of this order, returnable on 15th of July, list accordingly.
Blake.
May I? Well, here in this case, my lord, by page 17 order, my lord, the 11 portion is page 23-25. I am, my lord, the present petitioners accused and his vehicle was seized in connection of a cattle transportation case. And by the learned, he filed application for custody of the vehicle before the court of magistrate. Magistrate rejected it. Thereafter, appeal preferred under 12, section 12, and that was, my lord, your lordship will find. In the said appeal, the prayer, though allowed, directed to furnish bank guarantee. Page 25, relevant portion. Paragraph 14, page 25.
Yes.
Situated thus, the IO is directed to give Zimma of the seized vehicle to its registered owner on furnishing bank guarantee of rupees such and such, with direction to produce the same before the court as and when required during the pendency of the case. So this part, my lord, I am ready to furnish surety equivalent to the market value of the
But
vehicle.
law says bank guarantee.
No, yes, my lord. That distinction has been categorically drawn by a coordinate bench. I have annexed this order. Your lordship is talking about 11.5. Here, I have annexed this order of the coordinate bench. This is, of course, a reported judgment. What is the distinction is that only during the course of, if the application for custody is allowed during the course of investigation, then bank guarantee is must. Here my case is charge sheet has been submitted, and after charge sheet, I have filed application for Zimma. Your lordship may kindly peruse this order I have annexed. It starts from page 26. And relevant portion, your lordship will find page 28. Well, got it.
Yes.
Relevant, my lord, is Roman 1, clause Roman 1. Subclause 14 of section 7 of the Act 21, 3, 4, and 5 of section 11 of the Act 21, and section 102 of the CRPC is enacted to facilitate investigation and to give the police officer the power to gather evidence to support the allegation made, which includes seizure, search, seizure, and detain. The release of seized material as envisaged under subsection 5 of 11 and envisaged under 102 of CRPC are relatable only to the stage of seizure and under subsection 3 of section 11. 3 says seize who can seize? My lord, so during the course of investigation only. And under chapter 7 of CRPC respectively. And therefore such prescription cannot be made relatable to a provision of disposal of property during inquiry and trial. So trial stage is different. My lord is well aware about that fact, man. The act is silent as regards disposal of property during inquiry and trial. That being the
Cattle Preservation Act.
Section 11(3) says,
yes.
First, your lordship kindly peruse 11(3). Got it.
Yes.
A police officer not below the rank of sub-inspector or veterinary officer or the person authorized in this behalf by the state government, as the case may be, if of the opinion of that offence under this act has been committed or is likely to be committed, may seize any materials or carcasses or cattle or vehicle or conveyance which have been or likely to be used in commission of the offence from the premises so inspected, and may detain any person suspected to have committed such offence. So very clear, my lord, that is only in the time during the course of investigation.
Where it is mentioned that it is only during
Reported. Yes, the language is clear, though the investigation part is word is not inserted.
It gives power to the police.
Yes.
Stage is not given.
State not. It gives powers to the person categorized in this section. The first is police officer, not below the rank of sub-inspector, veterinary officer, or any person authorized on this behalf. Opinion that offence under this section has been committed or is likely to be committed.
Okay. Yes, Mr.
Now, your law enforcement 5. 5 says, on receipt of the report, the judicial magistrate first class may, on his being satisfied that there is enough material to presume that a prima facie offence under this act has been committed or intended to be committed, release this his material, including vehicle, conveyance, except cattle. So, in respect of cattle, I am not for cattle. Furnishing a bank guarantee equal to the value of the material, bank satisfaction of the court. So, this distinction has been drawn, dealt into by a coordinate bench, and it is held that section 5, subsection 5 of 11 is only during the course of, if any Zimma application is filed before searching, that means during the course of investigation. And the next paragraph of the order is very much clear, page 30, paragraph 7. Thus, in view of the determination made herein above, when the application for Zimma is filed after the charge sheet was laid,
Yes.
The consideration of grant of Jimma cannot be said to be an exercise of power under 5 of 11. And therefore, the insistence of bank grantee as prescribed under 5 of 11 shall not be applicable. So accordingly, there is a direction issued to release the vehicle on furnishing of surety.
Okay, yes, Mr. Sharma.
My lord, raising order.
After 2 minutes.
After 2.
This application under section 528 of BNSS 2023 has been made by the petitioner, namely Momar Ali Sheikh, impugning the judgment, impugning the ordered judgment and order dated 1/4/2025 passed by the Court of Learned Sessions Judge Kokrajhar in Criminal Appeal number 24/2024, whereby the order dated 7/8/2024 passed by Learned Judicial Magistrate First Class Kokrajhar in Serfan Guri, PS case number 15/2024 was reversed. The magistrate rejected your prayer, reversed, and the custody of the Bolero pickup vehicle, which was seized in connection with the aforesaid police station case, was granted to the petitioner. The petitioner is mainly aggrieved with the condition imposed by the appellate court of furnishing bank guarantee of rupees 6 lakhs as a for granting the Jimma of the vehicle to the present petitioner. Stop. The facts relevant for consideration of this criminal petition, in brief, are that in connection with Serfan Guri, PS case number 15/2024, which was registered under section 379/411 of IPC, read with section 13 within bracket 1 of the Assam Cattle Preservation Act 2021, the Bolero pickup van belonging to the present petitioner bearing registration number AS16AC 4517 was seized. The petitioner approached the Court of Learned Judicial Magistrate First Class by filing an application seeking Jimma of the seized vehicle. However, Learned Judicial Magistrate First Class Kokrajhar, by its order dated 7/8/2023, rejected the said prayer. Being aggrieved By the said rejection order, the petitioner approached the Court of London Session Judge Kokrajhar by filing an appeal under section
12 of the
under section 12 of the Assam Cattle Preservation Act 2021. Stop. The appellate court, by its judgment dated 1/4/2025, though allowed the appeal and reversed the order of the learned judicial magistrate first class. However, while granting the Jimma of the seized vehicle to the present petitioner, imposed a condition regarding furnishing of bank guarantee to the tune of rupees 6 lakhs on the present petitioner. Learned counsel for the petitioner submits that the condition imposed by the appellate court is too onerous on him to comply with the same. He further submits that the law, as clarified by a coordinate bench of this court in the case of Muhammad Johuruddin versus State of Assam, within bracket, judgment dated 22/5/2024, in criminal petition number 509/2024, has been clarified by holding that the grant of Jimma in a case where charge sheet has been filed is not to be regulated under section 11 within bracket 5 of the Assam Cattle Preservation Act. Learned counsel for the petitioner submits that the coordinate bench of this court has held that the release of seized material envisaged under section 11 within bracket 5 of the Act of 2021, as well as under section 102 of Code of Criminal Procedure, are relatable only to the stage of seizure under section 11 within bracket 3 of the Cattle Prohibition Act, and therefore the coordinate bench held that the said prescription cannot be made relatable to a provision of disposal of property during inquiry and trial. He therefore submits that in view of the observations made by the coordinate bench of this court in the aforesaid case, the impugned order may be modified and the petitioner may be allowed to furnish a bond and an indemnity bond to the tune of rupees 6 lakhs instead of bank guarantee, with any condition which may be imposed by this court. On the other hand, learned additional public prosecutor has fairly submitted that the provision contained in section 11 within bracket 5 is mainly to ensure that in a case if the production of vehicle is required during trial or investigation, the same may be ensured. Stop. I have considered the submissions made by learned counsel for both sides. I have also gone through the ruling of the coordinate bench in the case cited by learned counsel for the petitioner. I am in total agreement with the observations made by the coordinate bench of this court with regard to the applicability of provisions contained in Section 11 within bracket 5 of the Assam Cattle Prohibition Act 2021. I am also in agreement with the submissions made by learned additional public prosecutor that the purpose of the statutory provision contained in Section 11 within bracket 5 of the Assam Cattle Preservation Act 2021 is to ensure the production of the vehicle if and when required at any stage after seizure of such vehicle, either during investigation or in trial. As such, this court, considering the fact that the imposition of condition to furnish bank guarantee of rupees 6 lakhs on the petitioner appears to be onerous on his part, the impugn order is modified to the extent that instead of furnishing bank guarantee, the petitioner may furnish indemnity bond of rupees 6 lakhs for production of the said vehicle as and when required during the pendency of the trial before the trial court. With above observation, this criminal petition is allowed and disposed of.
Item 20.
May I please? Well, here in this case, an FIR was lodged against the present petitioner alleging medical negligence, and that was registered. So I have taken the ground basically that my lord is well aware that the Bolam test as held by the Supreme Court, that is mandatory, and preliminary investigation as held by the Constitution Bench of Supreme Court of Lalita Kumari in case of medical.
What is the stage of
FIR, my lord? So I am not pressing at this stage any interim prayer, my lord, only notice may go, my lord.
Mr. A.I. Uddin, learned counsel for the petitioner. Also Mr. B. Sharma, learned additional public prosecutor. This application under Section 528 of BNSS has been filed by the petitioner Dr. Partha Sathi Acharji, praying for quashing of the FIR, on the basis of which Lanka PS case number 41/2026 has been registered. Let the notice be issued to respondent number 2 and 3. The petitioner shall take steps for issuance of notice upon respondent number 2 and 3 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 16th of July. Let also the case diary be called for.
Notice registered the water.
16 July.
Bishop.
16 June.
After 20.
After 20 days. 22nd
Of
July.
line.
List.
Item 21.
May I please your lordship? Lordship, I am coming against the order dated 8/1/25, Lordship. Kindly come to page 25, type copy, Lordship. May I read the order, Lordship?
What is the order?
Yes, Lordship. Type copy, page number 26, Lordship. 26.
Yes.
8/1/20.
Page 26.
30. Sir, kindly come to page 30. She 0. 8/1/2025.
Order dated
Order dated 8/1/2025, Lordship. Last part of the PS, Lordship. May I read the order, Lordship? Here, accused is absent without step. Someone issued return with a report that the accused person could not be traced. Since the same heart issue non-bailable warrant against the accused, be it to take step fixed 24/2024 so appearance. What happened in this case, your Lordship, is that in the entire order sheet, Lordship, I annexed the entire order sheet, Lordship, from 2013 to 2026, Lordship. What happened in this case, Lordship, is that there is no any service report. I have never received any summon, Lordship, till date. And from 2013 to 2000,
When is the next date?
yes, Lordship, 17/6/2026.
You appear on the next date.
Yes, Lordship, I will appear.
We will.
I will appear and proceeding. I face the trial, Lordship.
What is your name?
K. Malakar.
Malakar. Third Miss K. Malakar.
K. Malakar, Lordship.
K. K or A?
K, Lordship.
King.
Yes.
Third Miss K. Malakar. Learned counsel for the petitioner. Also Mr. B. Sharma. Learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner impugning the order dated 8/1/2025 by which non-bailable warrant of arrest has been issued against the petitioner in connection with GR case number 2035/2014 pending before the Court of London Judicial Magistrate First Class, Boko. Learned counsel for the petitioner has submitted that the petitioner has never received any summons from the trial court. However, the trial court, by the impugned order, without verifying the service of the summons on the petitioner, issued the non-bailable warrant of arrest against him. And stop. She submits that the petitioner, when you came to know about the pendency of the case,
Lordship, 5 days ago.
the petitioner recently came to know about the pendency of GR case number 2035/2014 against him, and also the fact that a non-bailable warrant of arrest has been issued against him. She submits that the petitioner is ready to face the trial and cooperate in the trial. However, unless the impugn order is quashed and the non-bailable warrant of arrest issued against him is made ineffective, he shall be highly prejudiced. Learned counsel for the petitioner further submits that the petitioner has annexed all the orders passed by the trial court since the inception of the GR case, and nowhere it is indicated that the summons were duly served on the petitioner. Stop. On the other hand, learned additional public prosecutor submits that if the petitioner is ready to cooperate in trial, he does not have any objection to the prayer made by the petitioner. Stop. On perusal of the records, including the orders passed by the learned trial court in GR case number 2035/2024/2014, it appears that the trial court issued non-bailable warrant against the petitioner without ascertaining due service of summons on him. As such, the trial court was not right in issuing the non-bailable warrant of arrest. Accordingly, the order dated 8/1/2025 and subsequent orders to the extent of issuance of non-bailable warrant of arrest are quashed. The petitioner is directed to appear before the trial court on the next day fixed, that is 17/6/2025, to facilitate his appearance before the trial court. The operation of non-bailable warrant issued by the trial court shall remain stayed till his appearance before the trial court. With above observation, this criminal petition is disposed of.
Item 22.
May please, Your Lordship.
Yes.
I was a complainant in an NIAC case, my lord. After trial, the respondent, my lord, he was acquitted in the case. Thereafter, I preferred an appeal before the learned session judge, my lord. And the appeal was also dismissed and the order of acquittal was affirmed, my lord. So, we being aggrieved with the concurrent finding of acquittals, my lord, we have come before this honorable court.
What are the grounds?
My lord, the primary ground, my lord, is that the trial court as well as the appellate court has turned the presumption on its head, my lord. Your lordship knows under the NI Act, 139 mandates, it is the signature or the check is admitted, then the court shall presume that there is a legally enforceable debt or liability in favor of the complainant. Now, in this case, both the trial court as well as the appellate court have insisted that the complainant has been unable to prove the existence of a legally enforceable debt or liability. If your lordship will kindly come to page 43 of the appellate court judgment, madam.
Yes.
May I read the decision and reasons thereof, my lord? Para 7.
Yes.
May I read, my lord? One of the important criteria in a case for proving any dishonor of check is that a complainant in a case must prove, first of all, the existence of a legally enforceable debt or any kind of liability on the part of the accused towards the complainant. This is the first error which the appellate court makes, my lord. Now, in this case, the authorized person appearing before the complainant, that is PW1 so and so, during his cross-examination stated that he maintains a separate account for the accused, but the full details of the account is not submitted in court. The witness also stated that he has not submitted the CA report to show that a sum of so and so is due on the part of the accused. Though it is true that the checks issued by the appellant were dishonored, but the fact remained that the complainant could not show that there was any kind of liability on the part of the respondent for the amount shown, and that liability is towards payment due for purchase of fuel for the from the complainant firm. Thus, the vital part of the burden on the part of the complainant firm is missing, madam. Remainder part, just one more paragraph. I'll take your lordship to. The lordship will kindly come to para 40, page 45, madam.
Okay, we are issuing it. Heard Mr. S. Nawaz, learned counsel for the petitioner. This criminal petition under section 528 of BNSS, read with Article 227 of the Constitution of India, has been filed by the petitioner, namely Messrs. S. Sons Service Station, impugning the judgment and order dated 26/3/2026 passed by the Court of London, Session Judge Bilasipara, whereby passed by the Court of London, Session Judge Bilasipara, in criminal appeal number 5/2025, whereby the appeal preferred by the present petitioner was dismissed and the judgment dated 5/5/2025 of the trial court in CR case number 85/2021 was upheld. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 16th of July. Let the records of, you want another date?
21st of July.
21st of July. Let the records of the trial court as well as the appellate court be called for from the respective courts, registry to take steps for requisitioning the records. List accordingly.
I'm deeply obliged, madam.
Item 23.
May I please? We are praying for, by way of this application, quashing of a complaint case, and the complaint, my lord, will please to find page 154.
What is the ground for quashing?
My lord, this is a purely civil matter, which has been given the color of a criminal case. In a gist, my lord, the petitioner has appointed the complainant as his attorney to facilitate the sale of his plot of land. And the attorney concerned has facilitated the sale of the said plot of
At
land.
what stage the complaint is pending?
My lord, for appearance of the accused.
When is the next date?
My lord, it's in the month of September, 9/9.
Heard Mr. What is your name?
A.K. Rai.
Heard Mr. A.K. Roy. A.K. Rai, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner praying for, you are praying for quashing?
Quashing, my lord.
Quashing of the complaint case number 114/2024 pending before the Court of London, Judicial Magistrate First Class, number 1, Kamrup Metro. Issue notice to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 20 July. Let also scanned copy of the trial court records be called for. The registry to take steps for requisitioning the scanned copy. List accordingly.
My lord, I also pray for an interim order, my lord,
We are
Because-
fixing it before the next
But
date.
if I may make one submission, my lord.
What submission?
My lord, the person to whom we had entered into an agreement for sale has first initiated a complaint. My lord, if peruses page 122, similar complaint on similar facts.
The next date is on September.
My lord, but my lord, the nature of the case is such that similar complaint was made. The
No.
earlier complaint case, when it was stayed.
What will happen in between? I am not understanding. I am fixing the case next date in July. Your case is fixed
In the month of September.
September.
Right.
What we should stay in between? In between, nothing will happen.
My lord, then the interim period may be considered because the
No,
further
no.
proceeding of the case there. Because already, my lord, the similar.
You want your case to be dismissed.
Oh, my lord, I'm just humbly
Then why
submitting.
are you not understanding? It is not a case which necessitated any stay at this stage.
Item 24.
Diplomas.
May I please, Lordship? My lord, we have filed this criminal petition for quashing the share case number 16425, that is page 14, my lord. My lord, before going to that aspect, Lordship may kindly see page 16. She has filed this case. Only she was 2 days in my house, that I am the husband. And within 2 days, she could realize that her dream is shattered. So that is her case. However, Lordship may kindly see page 16, date of cause of action on 2/1/23.
What is the accusation?
Accusation is that I have tortured her and along with my old father-in-law, mother-in-law, brother-in-law, etc.
What is 316? It is corresponding to 498A.
Yes, 498, that is an IPC. That is the case number 249, my lord. 2 CR case she has filed. And 1 family court she has filed 125 proceeding. So within only 2 days she was in my house. Thereafter she started all this nuisance. And already 3 cases have been filed. Now Lordship may kindly see, because 4 cases, domestic violence also. Domestic violence is also there.
No. Now, which case you want to quash?
Yes, 164 we want to be quashed.
When is the next date?
18/6. 18/6. The
Or-
reason
or-
Lordship would kindly see, if your Lordship kindly go to page 16, Lordship would see 2/1, that is her cause of action, that is that of occurrence, 2/1/23 to 28/1/25. But since, my lord, now kindly see, now page 51, my lord. IPC.
Where is the complaint petition?
My lord, kindly see page 50, 50. 50, para 18. On 10/9/22, the complainant was asked to go to the parental home to bring the money as demanded by the accused persons. Now, Lordship, kindly see, on 10/9/22, and she has filed the case on 7/6/23, page 55. 7/6/23. Now, in her cause of, now kindly see page 16, she was all along at her home, all these days when she went to 123 to 28, 125, and she says, my lord, that no one went to take me back. Page 51, my kindly see page 51, para 22. That the accused number 1 also did not come to parental home of the complainant to take her matrimonial home. That means all this long time, that is from 2/1/23 to 28/1/25, she is at her mother's house. Now, how I can commit the crime on 10/9/22? She is at her mother's house at that time. And, my lord, another thing is this, my lord, she has sent some messages to me. Kindly see page 58. Page 58, kindly see. She is saying, when she went to her mother's house, she sent the message to me that I have filed false case only to harass you all.
Whether cognizance has been taken by the
The
trial.
cognizance has been taken, man.
Where is the order?
That order, my lord. Wait to one, episode to one. The former one is 149. Cognizance has been 249.
No, 164.
No, that is not taken. But we have received notice, and thereafter we have come. Because
No, then you can agitate before the trial court that cognizance should not be taken. Now only notice has been issued under 223. After hearing you, if there is no case, no cognizance will be taken.
perhaps
This
that
is not.
learned trial court would not consider they go for quashing, and that will be answer, simple answer. Because she has given.
Quashing is not proper at this stage. Because statute gives you a right of audience before taking cognizance.
My lord, my submission would be, my lord, when she was at her mother's house.
You can say all these things before the trial court. If trial court is convinced it will not take cognizance, if it still take cognizance, then you can come before this court.
Then no, we are for second case, man. We are for second case, 164.
Yes.
First one we will face the trial.
My question is also regarding.
All this is before the landed trial court.
Yes.
Then with that observation, case will be disposed of.
Heard Mr. M. U. Mahmood, learned counsel for the petitioner. Where is the order of issuance of notice? This application under section 528 of BNSS has been prayed for quashing of the CR case
Order
number.
page 43.
CR case number 164/2024. Page.
From the order, my lord, it appears the steps was asked to be taken, but she has not taken steps. So it means cognizance has been taken.
No, it does not mean.
Notice has been issued. Notice has been issued. Kindly see page 43.
Stop. Learned, Mr. M.U. Mahmood, learned counsel for the petitioner.
May I say one thing, my lord? As the notice has been issued, and there are simultaneously two CR cases against all the members of the husband's family, so lordship may kindly examine the matter, record may be called for.
You go before the trial court. Learned counsel for the petitioner submits that the complainant, Momina Begum, has instituted a complaint case alleging making accusation against the present petitioners under section 316 of BNSS and also making prayer therein several accusations against the present petitioners. He submits that the trial court has issued notice to the petitioners and fixed the next date on
18/6.
18/6. 18/6 for hearing. He, however, fairly submits that the trial court has not yet taken cognizance of offense, BNSS, offense against the present petitioners. It appears on perusal of the order dated 4/5/2026, which passed in CR case number 164/2025 by the Court of London Judicial Magistrate First Class number 4, Kamrup Metro at Gauhati, which is annexed as Annexure 3 along with this petition, that the trial court has issued notice to the present petitioners under section 223 under proviso to section 223 of BNSS at a pre-cognizance stage. It is only after hearing the petitioners the question as to whether cognizance may be taken or not will be decided by the trial court. As such, this court is of considered opinion that this is not a fit case to exercise inherent jurisdiction under section 528 of BNSS to interfere with the order of the trial court. The petitioners may appear before the trial court and may agitate their case so that may agitate their case so that no cognizance, may agitate their case stop.
Well, may I pray one thing? There are two CR cases, 164 and 249. So both the cases may be taken together. Then only will be better to understand the matter.
That prayer you have to be.
Actually, that was prayed for. When there are court cases, then or same cases between the two parties, they both cases will be tried together.
That prayer you have to make before the trial court.
That finally be observed. They do not try to understand. That is the problem.
No, you cannot make
It is settled position of law that.
No, Mr. Mahmood, you cannot make such accusation against a court that they.
No, I am not accusing, but we have tried.
You are unable to make them understand. if some court is not understanding something, it is your inability, not the court's fault. Don't make accusation against courts.
Well, I am saying that settled position of law that when there are two proceedings,
Chandika last name. May agitate their case before the said court. With above observation, this criminal petition is disposed of.
Item 25.
May I please your lordship? Lordship, matter may kindly be adjourned. Conducting advocate has some difficulties.
What is your name?
B. Kolita.
Heard Miss B. Kolita, learned counsel for the petitioner who seeks an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. The prayer is allowed. Let this matter be listed on 19th June.
June.
Item 26.
Much okay.
May it please your lordship. Lordship, we have come before this honorable court challenging the impugned NBW issued on 11/5/2026. Lordship, the petitioner's lordship went on bail lordship, ad interim bail lordship, anticipatory bail lordship, and thereafter charge sheet was laid lordship. Thereafter, the petitioner appeared before this before the honorable trial court lordship. Suddenly, lordship, on 11/5, page 39, lordship, on 11/5, there was flash flood, lordship. So the petitioner remained busy on harvesting of rice, lordship. So they could not appear before the court, lordship. And
But
they,
you were aware that on that day
lordship,
you have a case.
lordship. It has been written also in the order itself, lordship. Because of flash flood, lordship, they were busy in harvesting, lordship. On 11/5, they could not appear, so NBW was issued. We are ready, lordship. Will appear on next date, lordship, on 8/7, next date fixed, page 39, lordship.
You missed only one day.
Lordship.
Before that,
I also remain absent, but
with
that
step.
is allowed, lordship, allowed by.
With step. Yes.
The sheet is not before your lordship, before the impugned order, because there is an observation in the impugned order, page 39, lordship will see. This observation, lordship, sheds lights on the conduct of the petitioner, lordship. Since case is pending at the stage of consideration of charge since long time, but accused persons remain absent turn by turn on some or the other pretext, due to which there is sufficient delay in speedy disposal of the case. On last 2 dates, Saturday, Sunday, there was holiday on which the accused could have done their harvesting work. Today's ground of absence is not found to be convincing.
Lordship.
And before that, lordship,
Flash flood, lordship.
they have not annexed the order sheet. When they approach your lordship for this kind of
Order sheet, which earlier order sheets.
Earlier order.
They have annexed only one order.
Lordship.
Maybe the trial court, your conduct has reflected in the trial court's order.
Lordship. That I admit, and lordship, on the next date, 8/7, lordship, will appear.
No, let them appear. If they appear,
Lordship.
if they don't appear, the NBW will remain in force.
Lordship.
They will be apprehended. Heard, Mr.
I am R. Islam.
R. Islam, learned counsel for the petitioner. Also heard Mr. B. Sharma, done an additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioners namely, who are the petitioners?
Okay.
Lordship, NBW can be, lordship.
Available warrant of arrest against the present petitioner, rejecting their prayer for rejecting the petition filed by them for adjournment. and dispensing with their personal attendance before the court on that day. Stop. Learned counsel for the petitioner submits that on 11/5/2025, the petitioners would not appear before the trial court as they had to harvest their paddy due to flash floods, where is the flash floods?
Lordship, paragraph 11, page 9, Lordship, we have stated.
Due to flash floods which came on during that time. He submits that the petitioners are ready to appear before the trial court on the next date fixed and cooperate in the trial. However, unless the non-bailable warrant of arrest issued against them is stayed, they may be arrested, and in that case they will be highly prejudiced. On the other hand, Mr. B. Sharma, learned additional public prosecutor, has opposed the grant of any relief to the petitioner at this stage, mainly on the ground that bare perusal of the impugn order shows that the petitioners are not cooperating in the trial and were absent before the trial court on one or other pretext. And as such, the case could not proceed any further beyond the stage of consideration of charges. Stop.
First date for TC was 31/5/2025.
31/5?
2025. Since then, it is lying in the stage of TC Lordship. One year Lordship, it has been fixed for consideration of charge.
You pay cost.
Lordship, we are cultivated, Lordship.
So you will not go to the...
Surely, and if we could not appear on the next date, Lordship, then consequence may follow, Lordship. One chance, Lordship.
Stop. I have considered the submissions made by learned counsel for both sides. On perusal of records, it appears that the impugn order dated 11/5/2026 cannot be faulted with on any ground, as it has taken into consideration the past conduct of the petitioners in remaining absent on the fixed date since 31/5/2025. Stop. However, for the ends of justice, one more chance is granted to the petitioners to personally present themselves before the trial court on the next date fixed, that is 8/7/2026, and to facilitate their appearance before the trial court on the next date, that is 8/7/2026. The operation of non-bailable warrant of arrest issued against them by the trial court shall remain stayed till that date, that is 8/7/2026. With above observation, this criminal petition is disposed of.
They may kindly be allowed to remain on previous.
That prayer you have to make before trial court.
Obliged.
For reasons mentioned in the judgment, this appeal is partly allowed. And though the conviction of the appellant under section 341 and 326 of the Indian Penal Code are upheld. However, the sentence imposed on the petitioner by the trial court under section 326 of the Indian Penal Code is modified to imprisonment for 2 months, which he has already undergone, and to pay a fine of rupees 10,000, and in default of payment of fine, to undergo further simple imprisonment of 3 months. The fine, if realized, shall be paid to the victim, Gokul Sonwal. The petitioner is directed to surrender before the trial court on 10/8/2026 to comply with the directions.
Awesome. Item 27. May it please your lordship. I'm aggrieved by the order dated 18/6/2022, your lordship, by which cognizance was taken against me. Your lordship, in this case, while I was serving as a sub-inspector in Gwalpara police station, your lordship, I conducted an investigation, and during the course of the investigation, I was a probationer at that time. During the course of the investigation, I had called the complainant to the police station. The complainant has alleged that I had threatened the complainant, and also had beaten him. These are the allegations, your lordship. Your lordship may kindly peruse the order at page 23.
What is the stage?
Fixed for appearance, your lordship.
When?
Oh, I have already appeared, your lordship. Now it is for CC, consideration of charge, your lordship.
When is the next day? They are issuing notice. Notice we heard Mr. T. Devri, learned counsel for the petitioner. State is party. Also heard Mr. B. Sharma, learned counsel for respondent number 1. This application under section 528 of the NSS 2023 has been filed by the petitioner, praying for impugning the order dated 18/6/2022 passed by the Court of Learned Additional Chief Judicial Magistrate Gwalpara in CR case number 121/2017, whereby cognizance of offence under section 325/322/294/506/500/34 of the Indian Penal Code was taken against the petitioner. Issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice to the respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 20 July. Let also the scanned copy of the trial court record be called for registry to take steps for requisitioning this scanned copy, list accordingly.
I'm also praying for an interim, your lordship. Your lordship may kindly grant me the interim. Your lordship.
Next.
I'm a police officer. I have to face the trial. I have to
When is the next day?
Next date, your lordship. 10/7/2026, your lordship. 6 for April.
Or
6 for April.
let the notice be served. We will consider your interim prayer after notice is served on the respondent number 2.
Let me kindly be recorded in the order.
The prayer for interim relief would be considered only after due service of notice on respondent number 2.
I'm very grateful, Your Lordship.
May I pay your lordship?
Yes.
My lord, petitioner before your lordship is a educated unemployed youth. There is a, my lord, a scheme under the government of India for person who obtain the degree in BTech or engineering. There is a scheme and it's called Dindal Upadhyaya Sambhavyam Ujjana. There is accordingly, I have obtained a loan from the bank, my lord, because I did not opt for job. I opted for the business. Because nowadays, my lord, every engineers, instead of going for technical jobs and all, they have availed this procedure, facility, a scheme under the government of India. This is a very, my lord, innovative scheme. My lord, loan was sanctioned in the year 2022. Accordingly, I have obtained a quotation from the complainant for rupees, my lord, 34,50,000 for purchasing for procurement of machines. What happened, my lord? Instead of supplying the machine in time, the complainant delayed. So that I am, accordingly, he supplies some machine, my lord, that is also, my lord, assembled one, not the brand new.
What machine?
Yes.
What machine?
Yes, reversing machine. Machine is, my lord, regarding making of, my lord, a coffee cup, plate, and others, my lord. This is tools and machinery. I have took the quotation. Loan was sanctioned. The bank was encased the money credited to his account on 4/2/2024. 4/2/2024 directly in the account of the firm of the complainant. Thereafter, he could not supply the machine in time. Lastly, he supplied on, despite of persuasion, my lord, on lastly, some machines were supplied in November 2024, and one machine was supplied on 4/11/2025. When I inspected the machines, my lord, it found the machines were reimbursement or disassembled one, that is not a brand new. Then I asked for the, my lord, case memo, invoice tax, and also, my lord, warranty card of the machine. They failed to supply to me. I refused to accept the machines, my lord, one machine. I asked the owner of the farm to come over. In absence of you, I cannot allow you to unload the machine. Then what happened? He said he could not turn up. I filed an FIR. I took the machine to the police station at Arunachal Pradesh, my lord. The case was registered against him under section 318, subsection 2 and 3 of BNS for sitting and all.
Against whom? Against the
Yes.
respondent?
Against the respondent.
Okay.
Against the respondent. In counter to this FIR, my case, my lord, he has lost an FIR before the at Gauhati. That FIR was not registered. But it was not even, there is no inducement from the police itself. That his allegation is that I have not paid rupees 2 lakhs, and also I kept the vehicles illegally. I requested the owner of the farm, at least don't unload the machines. You please come over to Yajuli, Arunachal Pradesh. In presence of you, I will unload the machine. He could not. He given an excuses of election and Bihu. Then after, my lord, in order to counter his misdeed, his fraudulent activity against me, he filed a complaint. Now notice was issued against me. And the affair which I was lost before the Yajuli PS case, charge sheet has been filed. So whole process has been, I am an educated youth, my lord, unemployed youth. I took the loan. Instead of going for service, I preferred, now these days, my lord, engineers are mostly preferred, instead of going for jobs and all, they want to establish their own startup. This is the policy of the government.
Where is the complaint?
My lord, complaint is very funny, my lord, kindly see this. Page 47. Page 47 is the notice. is 48 onwards, 49 onwards is the complaint. Accused number 1 is the petitioner number 1. The accused number 2 is the father of the petitioner number 1. My lord, kindly see page 50, the allegation. The paragraph 4. The 23/3/2004 Toko Tadam and son of Toko Tite came to Ganapati Association. This is also wrong. I went there in 2023 for obtaining my quotation. And he said, I have supplied so and so machine. The cost of the machine is also there. I have paid the money was, bank has already paid the money directly to the proprietor of the farm in their account because it is a loan. In case of loan, my lord, the money has to be, loan amount has to be encased directly to the account of this farm, any farm, my lord, whom I used to procure the machine. This is the allegation, my lord. Now, paragraph 5 of the complaint is also that I have to pay rupees 2,70,000. This is the allegation. And paragraph 9 is a false and fabulous. This is a bold allegation against me, my lord.
Whether it is false or not, the trial court will find out. But
My lord,
finally,
kindly see that his own statement, my lord, kindly see his FIR. His FIR lost before the police, page 59. Page 59, my lord. Kindly see the complaint and the, my lord, his FIR before the police. Two things are contradictory.
how?
Here he said, remaining balance 2 lakh has not been paid. I have to get back money from him. He has not supplied the money. The machines which were supplied were all, my lord, old and assembled one. That is not brand new. And even when I inquired before the, my lord, GST authority, the tax has not been, GST has not been paid. Invalid invoice. He has issued me the invalid invoice so that I cannot claim warranty. Because it is a machine of, my lord, highly costable machine. Every machine carries a warranty. If you could not pay, supply me the, my lord, invoice, tax invoice, I cannot claim warranty also. This is the allegation, my lord. Kindly see page 59 for the police.
Where is the order of the trial court?
My lord, yes, my lord. Here only notice has been issued, my lord. I not any certified. On 15/3/2026, the case was registered. My lord, whether anybody can go to the court to file and without following the procedures. And 11/3, my lord, the examiner CW1, the complainant was examined. And 4/4/2026, notice was issued upon the petitioner. My lord, he is want to establish a business.
And when is the next date fixed?
My lord, next date your lordship may file is 16/6/2026.
You appear before the trial court.
I will appear, my lord. Problem is that I am unnecessary harassment.
No.
Because
This notice is issued at a pre-cognizant stage.
of
Court
course,
has,
my lord, under 223, my lord.
yes, court has not.
Provision is there, my lord. Proviso is
So
there.
it is not a fit case to.
My lord, problem is that I am suffering, my lord, unnecessary subject to an harassment to a fake and frivolous case. There is no case
Therefore,
against
the
me.
proviso of 223 has been incorporated in the statute so that you can convince the trial court
My lord,
that a
what
false case.
evidence is required, my lord, if the face of the record is shows. Even, my lord, what is his
No,
allegation?
your counsel may appear and argue the case. Even
My lord, of course, true, my lord. I am the resident from Arunachal, my lord. Going there again, it is an unnecessary harassment, my lord.
But this is not a case to interfere at a pre-cognizant stage.
My lord, lordship was right, but they cannot directly file and complain before the, unless they have approached the police. Police has not endorsed anything, my lord. Simply they have shown, in order to file the complaint, they have shown this page 59. Nothing is there, my lord.
That plea you can take before the trial court, because
Lordship.
court has not yet taken cognizance.
My lord, this is an innocent boy, my lord. After graduation, BTech.
Instead of rushing to High Court, you could have gone to the trial.
Obviously, my lord, because why I have before your lordship is there is no due payable to him, nothing. I have to get the money.
All these
The bank-
things, all these things have to be stated before the trial.
And the bank authority also said, my lord, repeatedly requested to him.
Bring these things to the notice of the trial court on the next date fix.
My lord,
Go to the trial court.
that is next is on 26, my lord, or only 16/6.
Yes, you
Tuesday.
appear there. And if any difficulty, you take time. But
The problem is that they are from Yazuli, Arunachal Pradesh.
from Yazuli, you can come to Gauhati.
No,
Why can't you go to?
Go there in Jorhat.
This
Not
is not a fit case for.
My lord, very systematically he was induced to buy the machines. That also assemble one supply.
All these things you can take plea before the trial court.
Lordship may observe this, my lord, my submission then. So that I can press before the learned court
Mr.
below.
S.K. Deudi, learned counsel for the petitioner. Also heard Mr. State is party? No. Stop. This application under section 528 of BNSS 2023 has been filed by the petitioners for quashing of the complaint case number 109/2026, which has been filed by the respondent before the Court of Learned Judicial Magistrate First Class number 3 under section 318 within bracket 2/318 within bracket 4/316 of the BNS. Stop. Learned counsel for the petitioner has submitted that the respondent has submitted that the respondent has filed a false complaint case against the present petitioners, alleging that an outstanding due of rupees 2,70,000 is there against supply of
Generator.
generators.
That was not supplied to me, my lord.
Is also alleged, it is also submitted that in the complaint petition, the complainant has also alleged that the present petitioners have illegally they retain the vehicle has been retained.
No, it was released, my lord. I have given to the police because he might be did not came to
Illegally
Yagili.
disposes the driver and handyman of the vehicle which went to Yazali for delivering certain machines to the petitioners. Learned counsel for the petitioner submits that, in fact, the petitioner, number one, is an engineer and has obtained loan under the government scheme, namely Deen Dayal Upadhyay Swalamban Yojana 2022-2023. And he submits that and loan of Deen Dayal Upadhyay Swalamban Yojana for starting his own startup unit of manufacturing paper plates. And as such, the respondent as such, and contract was entered into between the respondent and the petitioner number one for supply of machines for that purpose. Learned counsel for the petitioner further submits that since the money to be paid against the machines to be procured from respondent by the petitioner is financed by the bank under aforesaid scheme, the said money was directly credited to the account of respondents on 4/2/2024.
The next at page 30.
When counsel for the petitioner has submitted that the complaint case number
109.
109/2026 has been filed by the respondent only for purpose of harassing the petitioners, since the petitioners are resident of Arunachal Pradesh. Stop.
And also to counter the my lord, Yazuli PS case number 4 of
He
2026.
further submits that the petitioners also came to realize that the machines supplied to them by the respondents were not brand new machines and were only assembled machines without any warranty
And tax and invoice.
and without paying requisite taxes by the respondent. Learned counsel for the petitioner submits that the trial court has issued notice to the present petitioners in the aforesaid CR case number 109/2026. And next date is fixed for hearing on 16/6/2023. I have considered the submissions made by learned counsel for the petitioners. On perusal of the order dated 26/5/2026 passed in CR case number 109/2026, it appears that the notice issued to the present petitioner is at pre-cognizance stage under proviso to section 223(1) of the BNS. Hence, the petitioner would have ample opportunity to project their case before the trial court to plead against taking of cognizance against them in the said CR case. Hence, this court is of considered opinion that this is not a fit case to invoke the inherent jurisdiction of this court under section 528 of BNSS by interfering in the process of court in CR case number 109/2026 at this stage. The petitioners are at liberty to approach before the trial court to agitate their case before the said court.
Trial court may consider, my lord.
It will consider.
My lord, all these documents.
You may produce.
I'll produce, the trial court may consider in accordance with you.
Trial court, that is not necessary. The purpose is that after hearing you,
This boy, my lord, unnecessary subject to harassment.
the
whole purpose of
with,
the scheme
with
has been.
with above observation, this criminal petition is disposed of.
Yes.
Yes.
Submit to your lordship. Lordship, this is a criminal petition. I'm challenging the proceeding of the domestic violence case, lordship. What has happened? There was an earlier round of litigation, and after my marriage with my wife, that is the private defendant, the private respondent number 2, she has filed a FIR against me, lordship, after 1.5 years of marriage. Now, after that FIR was filed, I have approached this honorable court for quashing of that FIR. And there was a settlement between the parties, lordship. And that settlement, lordship would find at page number 29.
Okay.
As per the settlement, everything was over and we were supposed to try to live together if possible. If it is not possible, then we will file for mutual divorce. Now, lordship may kindly see the clause, lordship, in page number 33. Lordship got it, lordship? Page number 33. Trial period and future separation. Both parties shall sincerely try to continue their marital relationship from the date the first party resumes cohabitation. Number 2, if despite genuine efforts the marriage could not sustain peacefully, both parties shall be free to file a mutual consent divorce under section 13B of the Hindu Marriage Act 1955 without leveling any allegations or blames on each other or their family members. In such an event, both parties shall cooperate fully, expeditiously in the divorce proceeding and shall not claim or demand permanent alimony maintenance over so and so, and that it is mutually settled. Now, as per this agreement, lordship, this honorable court has quashed the FIR, which was filed by the respondent number 2. Subsequent to that, lordship, I have started to cohabit. But within 1 month, everything changed. Again, she has filed this case petition. Because
you started subjecting her to domestic violence.
No, that is different. No, because lordship, the allegation is that since I was not ready to settle the matter, I was not ready to live with her. That's why this has happened, lordship. Lordship, this cannot keep happening, lordship. And lordship, The mother also, the case has been filed against the mother also, Lordship, and this honorable court has stayed the proceedings pending before the court, Lordship, trial court, Lordship.
Which
This
proceeding?
Lordship. Did you?
No, which proceeding?
Same proceeding, Lordship.
DV.
This proceeding. DV.
Then why are you before this?
I'm the mother has filed a DV case, Lordship. I am the.
Now, DV case is has already been stayed.
Yes, Lordship.
Then we
No, I
need.
am challenging it. That was my mother who has filed this case.
So
Not
why a separate case is required?
That is, my mother is different, Lordship, and I am different, Lordship. My mother, I stay separately from them, Lordship. Because of all these marital disputes, I do not stay with my mother. My father and my mother stay separately.
The case has already been stayed.
Lordship.
Okay, we issue notice.
Lordship.
Heard, Mr. This item number?
P. Deka, Lordship.
Heard, Mr. P. Deka, Learned Counsel for the petitioner. This application under section 528, you have quoted wrong section.
Oh, Lordship.
528 of BNSS 2023 by the petitioner, namely Himanshu Kumar Das, praying for washing the domestic violence case number 58, washing the proceedings of domestic violence case number 51/2026, which is pending before the Court of London, Judicial Magistrate First Class number 4, Kamrup Metro at Gauhati. Learned Counsel for the petitioner has submitted that in a separate criminal petition preferred by the mother of the present petitioner, by order dated 23/4/2026, passed in criminal petition number 561/2026. The further proceeding of the aforesaid domestic violence case has been stayed. Stop. Issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let this matter be listed after 4 weeks.
Along with
criminal petition number 561/2026. Let the scanned copy of the records of the DV case number 51/2021 6 be called for from the trial court. The registry shall take steps for requisitioning the scanned copies of the records list accordingly.
Highly available.
Yes, Bharti.
May I please, my lord? My lord, this criminal petition, my lord, I was released on bail. I respectfully take my lord to page 126 of NHA 813, page 126.
What relief you are seeking?
126 NHA 813.
Yes.
The operative portion my lord will find in page 130. The third paragraph, in view of this aforesaid facts, 130.
Yes.
The third, in view of the aforesaid facts, I'm of the view that though the time interval between passing of the order at 12:30 and arrest of the accused 2025 at Central Jail Gauhati is small, there is no alternative for this court but to hold that the arrest was made prior to the passing of the order. My lord, before that, allowing me to arrest when I was behind a bar in another case in the judicial custody, that as such the same is illegal and without authority and jurisdiction of law. By this, I've been allowed, my bail application was allowed. Now next, page number 135, 135 in the same order. In view of the above, after discussion, though the today's order dated 29/5/2026, this is a bail order, the bail of the accused has been granted in view of the technicals and procedural defects depriving the liberty of the accused. That is next page 136. CBI shall not be precluded from again approaching the court for issuance of production warrant and to seek arraest of the accused in connection with the present case. I was granted bail on 29/5/2026, and in the same bail order, that there is also a direction given to the CBI that they will not be precluded for approaching for issuance of production warrant. Now, accordingly, on 29/5/2026, that was Friday. Saturday was 30/5/2026. Then Sunday. Then Monday was also holiday. Then on Tuesday, they have filed a production warrant before I could complete my formalities of furnishing bail bond and all. They have filed a production warrant, page 150.
What you are challenging here?
Page 150, that in Excel A16, this is the impugn order.
Page
150. This is what I have challenged. I was granted bail on 29/5. Before I could furnish bail bond, this 3/6 order was passed, allowing the production warrant and re-arresting me in the same case when my arrest was declared illegal and without authority of law. That is not only a technicalities, but that was without the authority of law that I was arrested. Case record is taken up on the basis of the petition number so-and-so filed by the prosecution for issuance of production warrant in respect of the so-and-so who is presently lodged in Central Gauhati, and to allow CBI to erase the said accused in instant so-and-so and in continuation of the order. I was released in RC6. That my lord will find that I was released in RC6. I have heard so-and-so, so-and-so, so-and-so. By the aforesaid petitions has prayed for issuance of production warrant in respect of so-and-so who is presently lodged in Gauhati, and to allow to re-arrest the said accused in the instant case. Releasing me on bail in RC6, and again another application has come to allow by the CBI to allow them to re-arrest me in the same before I could complete my formalities. This is the whole case. So there was also an undertaking taken from me that I shall not furnish surety, because that, my lord, page 148, annexure A15, there was on the reopening day, I was granted bail on 29/5. Then on the reopening day, there was Saturday, in fact, in between. Case record is taken up on the basis of petition so-and-so. That was on 2nd. Copy of the aforesaid petition was furnished and served upon learned counsel for accused at about 11:26 AM today via WhatsApp. I was out of station. And now the case is taken up. Hard so-and-so. Mr. Gunnar learned counsel for has joined and submitted he will physically appear before the court tomorrow. Mr. Submits and undertakes the bail bonds of the accused Assam Kanan shall not be furnished in respect of so-and-so. Even that I had to give that before the court at I undertook that I'll not even serve bail bond. Only on that condition, this petition was heard. Because even I was not even allowed to furnish bail bonds on second, in spite of the fact that I was released on bail. So my only humble submission is this particular 3-6 order is not tenable in the eyes of law.
No, why you said that you will not be filing bail bonds?
No, because it was served to me. So the court has asked me that only this petition will be taken up tomorrow physically, only on one condition, that if I undertake that, I'll not be furnishing bail bonds.
Where is that? That you will give that undertaking.
Undertakes that bail bonds of accused Assam Kanan Singh, that page number 148, the last sentence, Mr. Ganadhar Singh, learned counsel submits that undertake that bail bonds of accused Assam Kanan shall not be filed in respect of so and so till disposal.
Now which order you are impugning?
3-6, page 150, NHR A16. I'm praying for the stay of this particular order, whereby the production warrant was allowed and I was re-arrested.
You were again arrested.
In the same case.
Yes.
In the same case.
It's given final reply. In the meantime, any kind of interim relief may not be granted because the reason being he was involved in number of cases relating to arms looting from the battalions and other accusations.
We have to see the legality of order dated, where by the same order bail was granted, and
I was granted bail in the same case. Again, I was rearrested in the same case before I am released from the
without cancellation of the bail order.
Without. So my only humble submission is, my lord, any bail order can be challenged for rejection of the bail and for cancellation of the bail. Only when there's a question of perversity in that particular bail order, it can be rejected.
Let the CBI file written objection.
Now, in the meantime, I'll be behind the bar. My only humble submission is, my lord, one thing also can be done. Your lordship can impose certain condition that in the meantime, once it is there, I can furnish my bail bond. I'll not stay. I'll be in the jurisdiction of this honorable court. I'll not leave Gauhati. I'll be outside. But in the event, if your lordship says that this 3-6, and if the legality of this order, and if I fail, then I'll surrender again. But as per,
but you have not challenged the earlier order dated.
Because it is in my favor. Because I have been granted bail there.
But by the same order you...
No. By the same order, only a direction was given. It's true, I have no challenge because that order, if it remains, once it is stayed, 29/5/2026 order will be in existence. By this order, that bail order has been nullified. 29/5/2026 order has been nullified by this 3/6/2026 order. But 29/5/2026, I have been granted bail.
And the CBI was also not precluded from rearresting you.
Yes. Now, that itself is contained in that order. I agree.
You have not challenged that.
How do I challenge? Do I have to challenge the order part by part?
No. You have to challenge that order.
These CBI are not
precluded. So
Yes.
if there is a bail order, without cancellation of bail order, how CBI can arrest you?
That itself is not tenable in the eyes law, but
That
have been granted.
That appears to be contradictory.
That appears to be contradictory.
But you have not put that order to challenge. You have not challenged that order.
No, because there I am granted bail. And I can understand your lordships, but there again I am granted bail. That portion.
But the second portion you could have
challenged. Second portion, it's a direction. I am only, the moment they come, after I'm released, only then I can challenge. But before I'm released, I know, I can understand it all flows down from Mihirajas, because if it is, I'm released on technicalities for not furnishing ground of arrest, they can file this in, but here is a question that
You are behind the bar in connection of other cases also, or only in this case?
I've been granted bail in other cases,
Only in this case you are detained.
only in this case.
Kindly check 135 of the petition. In the last para, in view of the above, though by this order dated so and so, the bail of the accused has been granted in view of the technicalities and procedural defects. That's it. We are just following the orders. That's not.
So my humble submission is that this particular 3-6 order needs to be stayed. Once it is stayed,
No, without giving any observation in respect of the second part of 29.5, how this order can be stayed? Because 3.6 order is a follow-up of second part of 29.5 order. By the first part, you were granted bail. By the second part, CBI was granted liberty to arrest you.
Or do we require time to finally reply?
Let them file written objection. In the meanwhile, you also think over.
No, I'll think over. Now, what is the order? The reason for not challenging, my lord. 29.5, 2000, Annexure 813. Now, what it says, page 136, that second part, page 136, the second part of the order. Issuance of protection and to seek arrest of the accused in connection with the present case by following the procedure established by law. What is the procedure established by law? That is cancellation of bail. That has to be a cancellation of bail. That is what we call procedure established by law. The order also says that CBI can do everything, but as per the procedure established by law. Now, if the order is such that things has to be done as per the established procedure of law, then how can I challenge this order again?
Yes.
Because they have to do as per the established procedure. That is first cancelling the bail, then again re-arresting me. So if I'm agreed by the second part, but as per the procedure established by law, they have to follow the law again.
So you are challenging only 3.6.
Only 3.6. This needs to be stayed so that I can do my formalities and any condition can be imposed by your lordship.
Yes.
Any kind of interest may not be granted.
Why?
Because he has involved in a number of cases related to
No.
harms.
But once he has been granted bail, without cancelling that bail, how you can arrest him again?
During the order,
Order says that procedure established by law. And procedure is once bail is granted, same has to be cancelled. You file reply, I am granting them interim bail.
be granted, it's my humble submission.
It's my right under Article 21. And when the court is declared it's an illegal arrest without authority of law, if it is illegal arrest for not complying with 50, whatever the ground, that's a different thing. Without jurisdiction and authority of law.
Which is the court?
Special court CBI.
Then we are giving 2 days time to get the scan copy. I have to go through the records. On Monday or Tuesday, we are fixing it. Let them file the objection within that time.
Interim?
No interim now.
then I have to be behind the bar because I have been granted bail, but I cannot do anything. Look, the condition, I have been granted bail, and the court has said that you can do as per the established procedure of law, and I can even not even.
No, that before even granting interim, the court has to come to a finding that issuance of production warrant on 3/6 was in violation of the order dated 29/5. A finding has to be arrived at. To arriving at that finding,
My lord, this is
both
what
sides, both sides.
This is what Supreme Court said, and it have cited this also. This is what Supreme Court has said. There was discussed para 19 of the same judgment, running page number 11. The constitutional bench was Justice Brikamnath and Justice Sandeep Mehta. Para 19, the principle enunciated in the aforesaid decision makes it abundantly clear that when an accused is enlarged on bail, police custody cannot be granted so long as the order of bail continues to operate. In the present case, the accused appellant stand enlarged on bail by effect of 17 so passed by Lana, which has not been challenged before any forum, and consequently the grant of police custody in the face of an existing bail would amount to indirect cancellation of bail. In view of the impugn order so. So it amounts to cancellation of the bail order. By 3/6 order, the 3/6 order is cancelling its own bail in an indirect manner. So the established procedure of law is the first, they have to cancel the bail order, then they have to apply all other. This is what it indirectly cancelling the bail. In one end, the bail is granted, in another, it has been taken away. Of course, if there are supervening circumstances after I'm released on bail, they can come for cancellation. And if it suffers from irregularity and perversity, they can come for rejection of bail order.
Heard. What
MG
is
Singh.
MG Singh, learned counsel for the petitioner, also Miss B. Majumdar, appearing on behalf of M. Kumari, learned counsel for CBI. This application under section 528 of BNSS 2023 has been filed by the petitioner praying for washing of order dated 3/6/2026 passed by the learned special judge CBI in CBI, Gauhati, Assam, in connection with RC6 within bracket S /2023 /CBI /SCB /Kolkata, whereby the prayer for issuance of production warrant was allowed. No, Mr. Singh, you have not yet furnished bail bond.
Yes, I have not yet finished bail.
So you are during your custody, issuance of production warrant
In the
can
same,
be issued.
no, I'm arrested in the same case. Again arrested.
No necessity of arresting. You were not released on bail. Only bail order was passed, but
Ye-
you have not yet furnished bail bond.
Now, how do I furnish bail bond if I'm re-arrested again?
You are not re-arrested.
Yes, I'm re-arrested by this order. I have been re-arrested
By
again.
which order?
By 3-6.
3-6 only issues production warrant.
No.
Fail to furnish the bail bond.
Next page 156. 156.
Yes.
156, page number 156 is a continuation later on. SM Kanan Singh has been produced from Central Jail. So and so, since so and so, continuing about saying this.
Where are you?
The prayer IO for re-arresting the accused in connection with the case is allowed. Page 156. I am allowed. Considering the board aforesaid petition and in the interest of further invocation, the prayer of IO so and so of re-arresting of the accused Kanan Singh is allowed.
Lordship, may I?
And the accused is remanded to judicial custody in Central Jail. I have been again remanded back. 3-6.
Lordship,
Yes.
kindly give us little bit time to file a reply. So many confusions are going on. And this order,
But thing is, the violation is apparent. Without cancellation of bail, you just filed an application for re-arresting. You cannot re-arrest a person. But on the other hand, Mr. Singh, if re-arresting is allowed, it may impliedly means that this is a prayer for cancellation of bail. By implication, it may mean. This is to be heard. Let they.
My lord,
They filed an application for re-arresting.
before cancelling the bail.
The application for re-arresting can be deemed to be an application for cancellation of bail.
No, that is only for protection of re-arrest. Because the cancellation of bail and re-arresting is totally different. Because in the cancellation of bail, there are two things. The cancellation of bail can be
this need to be
no
considered.
Yes, I understand, my lord. Cancellation of bail can be done under a supervening circumstances. Rejection can be done under perversity and irregularity. Here, even I have not been even granted bail bond. Even I don't have time to even furnish my bail bond. Only one day. Then the second day reopening, they have come with this production. Now I have been behind the bar.
order can also say the CBI shall not be precluded from any.
Allowed.
And my lord,
by the same order, the petitioner was, by the same order, an application by CBI for re-arresting the petitioner was also allowed. Learned counsel for the petitioner submits that the order which has been impugned in this criminal petition is violative of rights of the petitioner, as once he was granted bail by the trial court without cancellation of the said bail order, he was allowed to be re-arrested, and as such the said order is liable to be quashed and petitioner may be released on bail. On the other hand, learned counsel for CBI has submitted that the CBI may be granted some time to file a written objection, and has also prayed for and has also vehemently opposed the grant of any interim relief to the petitioner at this stage. On perusal of the order which has been impugned in this case, it appears that whether in this criminal petition the court shall have to come to a definite finding as to whether any separate application for cancellation of bail by CBI was necessary under the facts and circumstances of this case before allowing the petitioner to be rearrested once he was granted bail by the trial court by its previous order dated 29/5/2026. The contentions raised by the learned counsel for both sides needs to be examined even for the purpose of grant of interim relief to the petitioner. Hence, the CBI is granted some time to file written objection. Next week,
Right? It can be fixed on Friday because my
when?
Friday.
Next Friday.
This, yes, that's on 18 or 19, any day.
On 19th. From that day, on 19th, list accordingly. The CBI shall file its written objection on or before that day with an advance copy of the same to the petitioner side.
Authorized.
May it please your lordship.
Yes.
My 28th application here in the affair has been.
Yes, what is this?
Lordship, here affair has been put under challenge, lordship. Affair starts from page registered under section 20.
What is the stage?
A stage pending investigation. And at this stage, may I please just issue notice to the respondent?
You are on bail.
I'm on bail, lordship.
Okay. Heard Ms. Tiso, learned counsel for the petitioner. This application under section 528 of BNSS 2023 has been filed by the petitioner Shri Gaurav Chakravarti, bring for quashing of the FIR on the basis of which Ambari Fatasil Ambari PS case number 59/2026 has been registered. Let the notice be issued to the respondent number 2. Also show presence of Mr. B. Sharma. And let the notice be issued to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 22nd July. Let the
June. Sometime in the month of June.
June last week, 25th June. The scanned copy of let also the case diary be called for. List accordingly.
Deep down.
May I please, my lord, before let's start. Can it be on 18, my lord? I'll inform CBI accordingly.
Okay.
18.
18. Okay. You have to inform the CBI.
I'll inform right now.
Made, my lord. My lord, the respondent are challenging the order dated 26/10/2022.
Respondent.
Respondents.
The brief fact of the case is that the respondent has filed a proceeding under section 133 of CRPC, alleging that the petitioner
Who is the respondent?
respondent is Ainul Ali and two others. All are from the same family only. Ainul Ali and Razak Ali.
Who has filed this petition?
It's IF Ali. I'm the petitioner and the respondent. They have already filed an application before learned magistrate, district magistrate under section 133 of CRPC. And an order was passed. That is in page number 42. We have challenged the order.
In this petition.
And being aggrieved with this order, we have filed this criminal revision petition.
Page number?
Page number 42, Annex 5.
Yes.
And they also have filed their affidavit in opposition, where they have challenged that the order dated 26/10/2022, which is later on passed, but it is consequential in nature, in comparisons to the order dated 31/8/2022, and which is liable to be set aside.
I am not getting anything.
They have no objection on other ground on the petition, but they have filed an affidavit in opposition challenging the order dated 22/10/2022. That is the impugn order which we have filed, we have challenged, and this order was passed.
Which one is the impugn order? 31/8?
31/8/2022.
No.
That is page number 48.
Now, where is that other order which you are referring to?
Other order is in page number 48.
Page number?
48, Annex 1 of affidavit in opposition.
Yes. What is this?
And both this order is consequential in nature. Setting aside of the order dated 31/8/2022 will automatically set aside this order dated 26/10/2022. And because of some communication problem, so we could not file this order on time.
Now, anybody has put this 26 or 10/2022 order to challenge?
My lord, both the orders are same, are consequential in nature, because the both order has same effect. And I'm aggrieved on both the orders, and it direct the petitioner in the same manner.
But you have not put 26/10/2022 order.
Lord, due to some communication gap with the petitioner
Yes,
and
Mr.
the council.
What is your submission?
Lordship, we are considering something. Firstly, Lordship, may I read page number 14, Annex 1, era 1 and 2 of this petition. Anagular, Lordship.
Page number?
Page number 14. Page number 14. Anagular, Lordship. প্রথম পক্ষগণ রেসপন্ডেন্টস লর্ডশিপ প্রথম পক্ষগণ বৈশারাগাঁও ঢুকিয়া ও সহজ সরল নাগরিক হওক প্রথম পক্ষগণ পূব বনভাগ মৌজাৰ অন্তৰ্গত ঘগ্ৰাপাৰ ৰাজহ চক্ৰৰ অন্তৰ্গত বৈশাৰাগাঁৱৰ স্থায়ী বাসিন্দা হওক বৈশাৰা নামঘৰ প্ৰাংগণৰ পৰা চত্ৰা নাৰপাৰালৈ যোৱা ৰাস্তাটো চৰকাৰী মানচিত্ৰ মতে 69 নম্বৰ দাগ পাট্টাৰ 340 আৰু 342 নম্বৰ দাগৰ পশ্চিম ফালে আছিল. Once upon a time, there was a road. কিন্তু কালক্ৰমত ৩৪০ আৰু ৩৪২ নম্বৰ দাগৰ মাটিৰ পট্টাদাৰ লাৱণ্য চৌধুৰীয়ে উক্ত মেপত থকা ৰাস্তাটো দখল কৰি ইয়াৰ পৰিৱৰ্তে দ্বিতীয় পক্ষই বৰ্তমান দখল কৰি থকা দ্বিতীয় পক্ষ মিনছ লৰ্ডশ্বিপ পেটিচনাৰ ইয়াত কৰি থকা জমিৰ উত্তৰ আৰু পূবফালে নিজৰ সুবিধাৰ বাবে আজিৰ পৰা প্ৰায় ৫০-৪৫ বছৰমান আগতে এটা প্ৰস্তাৱিত ৰাস্তা উলিয়াই দিয়াৰ পিছত বৰ্তমানে সেই ৰাস্তাৰে স্থানীয় ৰাইজে চলাচল কৰি আছে। এই কথা বৈচাৰা গাঁও ৰাইজৰ ভালদৰে জ্ঞাত আৰু প্ৰথম পক্ষগণে জনা হোৱাৰে পৰা উক্ত ৰাস্তাৰে চলাচল কৰি আহিছে। ২ নম্বৰত লিখিছে লৰ্ডশ্বিপ নাম্বাৰ 2, যদিও উক্ত প্ৰস্তাৱিত ৰাস্তাটো ১৩ ফুট আছিল, এতিয়া প্ৰায় ৮
No.
৮-৯ ফুট।
Yes, if you are challenging the subsequent order,
My lord, first of all, they have admitted this is a private land in the first paragraph, as my opposite counsel has read they have accepted it.
we are admitting this revision petition, fixing a date for hearing. If before that, if you think that there is any amendment is required,
My lord, there is a road, still there is a 12-foot road. And this is their submission. What they said is 8 or 9-foot road is remaining. And in the order of 31/8/2022, in the schedule of land, it is already mentioned a road measuring 12 feet wide covered by DAG number 34 and 342 or Patta number 69 of Paisara Charali Chatra connecting road under Pub Banbhag Moja under Gopal River is bounded
fixing
by.
it next week.
So the occupation, if they are saying that we have possessed the land, it is not proved. And nowhere in the evidence it is said that the officer during investigation that it has been occupied by us. So
Lordship,
they must face the trial for this.
Lordship, present road is not east side. And previous road was on the west side of that plot of land.
We have also.
But the previous, not a bit of my friend. But the previous road was endorsed by the petition. And the previous road only on paper now. The present road is, of course, on their private land, but it has been using by the public.
Next week at the review. I am fixing it for hearing.
And my lord, annexure 4 is also there where we can see the police reports.
More prepared next time. Heard, Miss, what is your name?
Error.
D. Roy Lanet.
Error.
Heard Miss D. Roy. A. Roy Lanet, counsel for the petitioner. Also heard Mr. D. Kolita Lanet, counsel for respondent number 1, 2, and 3. This revision petition is admitted for hearing. Let this matter be listed for final hearing, 18th of June.
May I please, Your Lordship? Is the appeal against conviction, Your Lordship? Your Lordship, the last date, last order, Your Lordship, 26/5/26, Your Lordship, already TCI was called for, Your Lordship. My appeal is to be admitted, Your Lordship, and reminder be issued for TCI, Your Lordship.
Miss S. Nazneen, Lanet, counsel for the appellant. Also heard Mr. B. Sharma, Lanet, additional public prosecutor. This appeal under section 419 of
BNS.
419 or
415, Your Lordship.
415 of BNSS has been. Where is the memo of appeal? (415) of the BNSS has been preferred by the appellant Shankar Kumar alias Gautam Sonar, impugning the judgment and order dated 27/3/2026 passed by the Court of Lanet's Special Judge Udalguri in special POCSO case number 123/2024, whereby the present appellant was convicted under section 376 of the Indian Penal Code and was sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 20,000, and in default of payment of fine to undergo simple imprisonment for two months. The appeal is admitted. It appears that the records of the trial court have already been called for, but same has not yet been received. Hence, issue reminder for the same. Let this matter be listed 25th June.
Please, Your Lordship. So the petitioner was granted interim on 19/3/2026. The CD was called for.
Yes.
As per CD Lordship, it is regarding Lordship seizing of 24 numbers of bulls, Lordship. CD reflects that Lordship, one or two witnesses implicated that he is engaged in such kind of businesses that
He was granted interim bail.
Yes.
Thereafter, whether he appeared before the.
His statements are recorded, Lordship.
Okay, whether you require his custodial.
Because Lordship, CD does not reflect that those seized cattle belongs to him or he has brought it. Lordship, that is not reflected in the sentence.
Now, whether you require his detention or not.
That is difficult, Lordship. So,
Heard.
because main two accused persons are yet to be arrested.
But he is cooperating.
Yes, exactly.
Heard Mr. M.H. Ahmed.
N. Zaman, Lordship.
Heard Mr. N. Zaman, learned counsel for the petitioner. Also heard Mr. P.S. Locker, learned additional public prosecutor. Learned counsel for the petitioner submits that the petitioner was granted interim bail by a coordinate bench of this court on 19/3/2026, and in pursuant to the directions of this court, he appeared before the investigating officer of Vipuria PS case number 25/2026. Stop. Mr. P.S. Locker, the learned additional public prosecutor, has produced the case diary of Vipuria KPS case number 25/2026 and has submitted that though the petitioner has appeared before the investigating officer and his statements were also recorded, however, there are incriminating material against him and a few co-accused are yet to be arrested. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials on record, including the case diary. Since the petitioner has appeared before the investigating officer in pursuant to the directions of this court and is cooperating.
So he was given interim while he was in custody, Lordship.
Yes.
So subsequently, his statements is not recorded. Earlier, during his custody,
Okay,
statements were recorded.
Continue. Since the statement of the petitioner has already been recorded by the investigating officer. This court is of considered opinion that if he cooperates with the investigating officer, his further detention may not be necessary. As such, the interim bail granted to the petitioner by this court by its order dated 19/3/2026 is hereby made absolute with following conditions. Condition number 1 and 2. With this observation, this bail application is disposed of. Send back the case diary.
Obliged.
Item 45.
Lordship, matter may be adjourned for the day, Lordship. As learned counsel, JUNM Lashkar is not well today.
Who is not there?
JUNM Lashkar, Lordship.
Case diary is there? Okay. Heard Miss R. Roy, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner seeks an adjournment as the engaged counsel for the petitioner has some personal difficulty. The prayer is allowed. Let this matter be listed again. 24th June.
Obliged, Lordship.
Item 26.
Lordship, service of
Yes,
the report is still awaited, Lordship.
we have taken steps upon respondent number 2, madam.
So matter.
Yes, madam, it's a POCSO matter. Although, madam, TCR has been received in this case.
When can you?
Steps were taken on 5th of this month.
This month.
So let it be after.
Maximum penalties.
Heard Mr. M. A. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who seeks some more time to inform this court regarding the service of notice on respondent number 2. The prayer is allowed. Let this matter be listed 19th of June.
Madam, deeply obliged.
7.
That's it submitted, Lordship.
Lordship, kindly matter may be passed over for the time being, because my senior is lagging at court number 7.
Charge sheet has been submitted. Who is your senior?
It's Sir Sodhori.
Let him come.
Item 38.
May I please your lordship, regular bail application as and today, my lord, as on today 47 is on 3 consecutive days, my lord, today CD is not, and victim also recovered, my lord. Today is the 3rd date, my lord.
CD has not arrived. What is the offense?
Offense is, allegation is kidnapping, my lord.
Case
this is
diary
a-
would be necessary.
But then, my lord, this matter will be fixed on 17 because in this regard, my lord, another 2 bail application, which is fixed on 17, my lord.
Heard Mr. A.I. Hussain.
MAI, my lord.
Heard Mr. M.A.I. Hussain, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for production of the case diary. Prayer is allowed. Let this matter be listed on 17th of June for case diary.
Along with BA application 1465 and
Along with BA application number
1465 2026 and
/2026
and 1399/2026.
Item 49.
Pardon, your lordship. Item number 33, lordship, is the IA, lordship. IA is to be heard after receipt of the LCR, lordship. Item 33, IA.
39. Item number?
33, Your Lordship.
Item number 33, in IA, this interlocutory application shall be taken up for consideration after receipt of trial court records. In the meanwhile, the state may file its written objection if it desired to do so.
Oblige, Your Lordship.
Given item E9.
May I please, Your Lord?
Item number?
483 application, my lord. I am behind the bar just 1 year, my lord. 364 days plus 1 day. This is a case that, my lord, I am having a shop come residence. Suddenly, my lord, on 12/6/25, the police entered to my shop and picked up the bag, kept upon a Godrej. So, my lord, it was containing fake currency. And accordingly, I was arrested and detained since then, last 1 year. And a charge has been framed under 180 of the VNS. And in the meantime, 3 witnesses have been already been examined. And, my lord, I have prayed for bail before the trial court. And my trial court has rejected. Trial court has admitted that there is a violation of 36 of the VNSS. But court has given reasoning that 36 non-compliance of therefore renders of arrest cannot be illegal.
Where is the?
That is the order sheet, page 46, my lord. Page 46, on perusal of the arrest memo, my lord. Third paragraph.
Yes.
On perusal of the arrest memo, under 36 BNSS, it appears that no signature of the witness or relative is available. However, 36C provides that every police officer, while making an arrest, shall inform the person arrested, unless the memorandum is attested by a member of his family, that he has the right to have a relative or a friend or any other person named by him to be informed to his arrest. In the instant case, though there is no signature of the witness or relative in the arrest memo, but the concerned police officer served notice under 48 BNSS to the wife of the accused, namely Purana Begum, hence the submission made by the learned counsel appearing for the bail petitioner that the attestation of the arrest memo by at least one witness is mandatory under section 36 BNSS, and non-compliance thereof renders the arrest illegal, thereby entitling the accused to be enlarged on bail, is not squarely applicable to these facts and circumstances of the case. This is one point. Thereafter, my lord, till today, my lord, I have not utilized, I have assuming that a bag was recovered, but there is no evidence that I have utilized this fake currency, my lord. Or I have given it to anybody in exchange of genuine notes. There is no such material, my lord. My lord, in a case of Avtar Singh versus State of Punjab, Supreme Court has held that conscious possession is a sine qua non for holding the accused guilty. In this case, a bag was found on the Godrej of my shop cum residence, my lord, and it was police entered to my house and picked it up. And case was charge was framed, and my lord, accordingly, again in the similar case, Umashankar was State of Chhattisgarh, Supreme Court held that in absence of proof that accused knew the currency to be counterfeit, conviction cannot be sustained. Then, my lord, again, my lord, in the Muttiki versus State of Karnataka, the Supreme Court observed that mere possession of a counterfeit currency without proof of intent to use the knowledge. I have not used it to anybody. I have not given it to anybody. My lord, recently there is a case happened in Maligaon station, my lord. From the Facebook, there is an ad that if you give 1 lakh, I will give you 2 lakh. Say, boy, unemployed boy, NH 2 lakhs. He came from Uttar Pradesh and met the man in the Kamakhya station. He said, no, you come to Kamakhya temple. I will give you money there. You pray first and I will give you. He went accordingly, Kamakhya temple, and gave the 2 lakhs genuine currency and brought the bag. And he was with a happy mood. He was going to Uttar Pradesh. In a Kamakhya station, he was caught. So, my lord, there was no intention, and He has not utilized it, nor even given to anybody. Here in this case also,
No,
at least the bag was found.
no, Mr. Vishwas.
Yes, madam.
At the stage of considering bail, we are not sitting on trial to.
My lord, then I am leaving everything, my lord. 36 is there. If your lordship consider, otherwise, my lord, my detention period, 1 year I have.
Yes.
Maximum punishment. Honest Kumar was also not applied, my lord, in this case.
That may be
7 years punishment, my lord.
that may be a valid submission. Yes, Mr. Sharma.
36 lordship, observation lordship is already seen at page 46. Nothing more to add on that lordship. And regarding
What is your observation on the observation made by court?
Yeah, on length lordship, we have discussed this lordship and the argument has also been made. So lordship
Whether
has
court
already-
is right, trial
lordship
court.
has already taken a view lordship, so
36 has been violated.
Yes, your lordship has
already
taken.
taken a view lordship. There's a
There are coordinate bench also considered it is a violation of fundamental
we
rights.
are not the coordinate bench, some coordinate bench have also
Yes, there is a different view also.
taken a different view. So lordship, since lordship has taken a view regarding 36 lordship.
No, otherwise 1 year has been passed.
1 year completed, my lord.
Lordship, but the 3 numbers of witnesses have been examined out of 6.
No, there is no, with respect, my lord, there is no independent witness, my lord.
No, other
Sorry, I'm sorry.
Very difficult.
Yes.
3 PWs have been examined out of 6. And charges were framed on lordship 29/11/25. And lordship, this offense, this is from 180 of BNS lordship. And it has been held by many judgment lordship. I am not burdening your lordship because this relates to fake currency. So it has been held by the Supreme Court of lordship. This acts as a heinous offenses, very separate from other offenses lordship of the IPC lordship, because this is a crime against the sovereignty of the nation lordship. And lordship, regarding this conscious possession and all lordship, that has been taken care of by incorporating 180 charges has been framed. This is in possession of counterfeit notes lordship. It has been seized from the living room of the present petitioner from his Godrej. Rest I leave it to your lordship.
Okay, heard Mr. A.C. Vishwas, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner Sheikh Robiul alias Sheikh Robiul, who has been detained behind the bars since 14/6/2025, within bracket for almost 1 year, in connection with special NIA case number 33/2025 under section 318/112 within bracket 2/179 of BNS 2023. The facts relevant for consideration of the instant case is that the present petitioner is charges are framed under what provision?
180.
180, 7 years punishment, madam.
180.
180 BNS.
Codes or counterfeit coins, government stamps, currency notes or bank notes.
BNSS.
Should I give, my lord?
No. BNS. That the present petitioner is facing trial under section 180 of BNS for possessing fake currency within bracket 100 numbers of denomination of rupees 500 notes amounting to total rupees 2 lakhs, bracket close. Learned counsel for the petitioner, Mr. S.C. Bishwas, the learned counsel for the petitioner has submitted that the maximum punishment provided for the offense with which the petitioner has been charged with in the pending trial is only up to 7 years. Only is imprisonment which may extend up to 7 years. However, the petitioner has already undergone detention for almost 1 year. He further submits that there has been a violation of provisions contained under Section 36 of BNSS 2023 at the time of arrest of the present petitioner by the arresting authority. He submits that the arrest memo, in the arrest memo, no signature of any attesting witness was obtained as required under Section 36 within bracket 1B. Within bracket B, within bracket small 1 of the BNSS 2023. He further submits that the petitioner agitated this issue before the trial court. However, trial court took a wrong view that as the family members of the petitioner were intimated regarding the arrest of the petitioner, no attestation of as the family members of the present petitioner were intimated about the arrest, the necessity of the mandatory provision of Section 36 BNSS is not applicable to his case. He further submits that in the meanwhile, in the pending trial, already 3 out of 6 witnesses have been examined, and as such, he submits that the petitioner may be allowed to go on bail. On the other hand, learned additional public prosecutor, Mr. B. Sharma, has opposed the grant of bail to the petitioner on the ground that the offense involved is regarding possessing fake currency, which has an impact on the economy of this nation. And as such, though the punishment is only up to 7 years, the offense involved may be regarded as a heinous offense. Anything else? Stop. I have considered the submissions made by learned counsel for the petitioner. The requirement of attestation by one independent witness under Section 36B is a mandatory provision irrespective of fact that under section 36E and 36C, the police is required to inform about the fact of arrest to the inform the arrested fact of arrest, inform the arrested person that he has a right to have a relative or a friend or another person named by him to be informed about his arrest unless the memorandum is attested by any member of his family. The requirement of B requirement contained under provisions 36 within bracket B and 36 within bracket C are both mandatory in nature, and one does not dispense with the other requirement. As such, trial court was not right in holding that the non-compliance of provision contained in section 36 BNSS had not rendered the arrest of the petitioner illegal. So, moreover, the petitioner has already been detained behind the bars for almost 1 year, and already 3 prosecution witnesses have been examined and only 3 are remaining. As such, if he cooperates in the trial, his further custodial detention may not be necessary for fair completion of the trial. Under aforesaid circumstances, the above named petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of the trial court with following conditions. Trial conditions.
Session Special Judge Kachar Silchar.
Session Special Judge Kachar Silchar. With above observation, this bail application is disposed of.
Development.
May I please, Your Lordship? Lordship, intermediate quantity. Caesar is at page number, Lordship 19, relevant type copy. And
what is the contraband?
Contraband was heroin, 15.30 grams in total.
Charges were filed on 19/5.
Next date is
B. And next date
is on the
6/6.
no.
Was 6/6/26 for evidence.
No, now it was fixed on 26.
Since when you are behind the bar?
From a date of arrest to days, 78 days. 27 March.
Why trial court rejected?
Yeah. Order is at page number 30, Your Lordship. And only considering the nature and gravity of the page number 33, Your Lordship, the relevant portion. Considering the nature and gravity of the offense involving recovery of heroin, which has seen serious adverse impact on society at large, and taking into account the material available on record, this court is of considered opinion that this is not a fit case to grant bail.
where trial court has gone wrong? Trial court has observed right things.
See, that is correct.
If that is correct, your bail is to be rejected.
But my lord, considering the quantity and my period of detention, there is no embargo of
Quantity is
intermediate 15.30. There is no embargo of section 37 also.
His embargo may not be there.
Your lordship, I'm ready to face the trial.
Witnesses, evidence is not yet started.
8 witnesses, your lordship.
8 PWs are there.
You will influence the witnesses.
There, most of them are government witnesses, all, your lordship. Only means Caesars, 2 Caesar witnesses only, but other are all official witnesses.
Yes, Mr. Sharma.
I would say that at least the Caesar witnesses may be examined. Then it may be considered.
It will take time, your lordship.
No leniency may be shown in any case.
Then we will direct the trial court to examine Caesar witnesses first, as first witnesses, and thereafter the trial court will consider your bail application.
Or this for the time being, this petition may be kept in abeyance also, till the consideration of the Caesar.
No, you may approach, we'll keep it open that you can approach the trial court. Trial court will, there is no embargo for trial court to grant bail. Heard Mr.
M.R. Sodial.
M.R.
Sodial.
Sodial, learned counsel for the petitioner. Also Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely
Majmul Hussain Laskar.
Mazmul Hussain Laskar, alias Nazmul Hussain Laskar, who has been behind the bars, detained behind the bars since 26/3/2026, within bracket for last 78 days in connection with NDPS case number 52/2026, arising out of Giri Ghat PS case number 10/2026 under section 21B/29 of the NDPS Act 1985. The facts relevant for consideration of this case in brief is that the petitioner is facing trial for charges under section 21B 29 of the NDPS Act 1985 for possessing intermediate quantity of heroin within bracket. How many grams?
15.30.
5.30 grams. Stop. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars for last 78 days and he is ready to face trial. He submits that there is no embargo in granting bail to the present petitioner for possessing intermediate quantity of heroin. However, the trial court has rejected his prayer for bail, only considering the adverse impact of the offense on the society at large. On the other hand, learned additional public prosecutor Mr. B. Sharma has objected to the grant of bail to the petitioner at this stage and has submitted that the trial court has made the correct observation while rejecting the bail. He submits that the charges were framed against the present petitioner on 19th of May 2025 and there are 2026 and there are how many witnesses? There are total 8 witnesses. He fairly submits that at least 2 Caesar witnesses witnesses who are very vital to prosecution case may be examined before the petitioner, before considering the prayer for bail of the petitioner. Stop. I have considered the submissions made by learned counsel for both sides. Though there is no embargo, no statutory embargo in granting the bail to the petitioner at this stage. However, considering the submissions made by learned additional public prosecutor, which in the considered opinion of this court are fair submission, that at least Caesar witnesses may be examined before the prayer for bail of the petitioner be considered. Accordingly, this bail application is disposed of with an observation that, with a direction to the trial court to ensure to examine two Caesar witnesses as the first witnesses by the prosecution side in the pending trial before it, and thereafter the petitioner shall be at liberty to approach the trial court seeking bail, which may be considered by the trial court accordingly. With above observation, this bail application is disposed.
Intent have been issued to the witnesses. So if they are examined also, let's say there will be no impediment.
Yes.
How much is
If in the meanwhile summons were already issued to other witnesses, there shall be no impediment on the part of the trial court to examine those witnesses also. However, it shall still make endeavor to examine the Caesar witnesses at the earliest. With above observation, this bail application is disposed of.
Item 41. Same motive, AID quantity is higher, 220 grams.
Page number 20, your lordship, is the Caesar 11 portion, 220 grams. But I'll take your lordship to page number 28, which is the arrest memo. Here, no signature of relative or witnesses has been taken, which is violation of 36B1. And today, as on today, the accused is behind bar for 98 days.
Abhishek, change karo. One. Page number
28, your lordship. Arrest memo. Column number 6. No signature of relative or witnesses of arrest. Only the signature of the accused person has been taken, arrested person. The quantity is intermediate.
How many days you are behind?
98 days as on today.
The only thing, lordship, whether they have taken this ground while preparing the bail application before the court below. That's what they should do it at the first instance, lordship.
Yes. Before this court, they have taken that plea.
I'm submitting this bail application which they have preferred before the court below, lordship. There they did not take up this ground, lordship. So that was no, lordship, that was that was before filing of the charge sheet, lordship.
Yes.
Bail order.
Was before submission.
This bail order is before the
Charge sheet.
submission of the charge.
But there is a violation, 36.
Lordship.
Heard Mr.
MR Sadial.
M.R. Sodial, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely
Vishal Das.
Vishal Das, who has been detained behind the bars since
6/3/26.
6/3/2026, within bracket for last 98 days, in connection with NDPS case number 56/2026, arising out of Jirighat.
Your Lordship, there is a mistake in this part. It should have been Lakhipur case number.
You correct that.
Yes.
Thereafter, I will
Yes, Your
pass
Lordship.
on.
Just now, but in the prayer portion, let me check, Your Lordship. In the
No,
prayer portion, it is Lakhipur.
No, rectify this.
By hand or I'll have to file an I.
You filed an amended cost item.
Okay. It will be reflected in the order.
Not Mr. So-and-so. Learned counsel for the petitioner praise for allowing the petitioner to file an amended cause title to rectify a typographical error in the instant bail application. The prayer is allowed. Let this matter when
Next week, any date, Your Lordship, on 16th.
16. Let this matter be listed again on 16.
May it please the Lord. Lord, it's a regular bail application, my lord. I'm preferring, my lord, this bail application, my lord, mainly on, my lord, three limited grounds. Thank you. Good. Thank you. My lord, as per the FIR, my lord, as per the FIR, my lord, the petitioner, my lord, while he was traveling in a New Delhi Rajdhani Express, my lord, around 26.9 kg of ganja was allegedly recovered from a trolley bag. But as per the seizure list, my lord, that is 25.9 kg ganja, my lord. But as per the FIR, it is 26.9 kg ganja. And the FIR, my lord, was registered under 20B2C NDPS Act. Now, my first ground, my lord, I have prepared a note, my lord.
Yes.
My first ground is that, my lord, the petitioner, my lord, was likely produced before the magistrate, my lord, after expiry of 24 hours, my lord. Because if your lordship will see from the FIR, he was initially detained at 8:20 a.m. in the morning. 8:20 a.m. in the morning. And the seizure list, my lord, as per the seizure list, the materials, my lord, the contraband was seized at 10:03 a.m. And the arrest memo at page number 23, it indicates that the date and time of arrest was shown to be 17/12/2025 at 11 a.m. handwritten. So he was shown to be arrested, my lord, after expiry of 24 hours from the initial detention, my lord. And thereafter, my lord, he was produced before the magistrate, and the time of production, my lord, is not known, my lord, because the production, my lord, the forwarding report also does not contain the time. So possibly it will be after the expiry of 24 hours. So that will be clear violation of the mandate of the Honorable Supreme Court in several judgments, my lord, including the recent judgment, my lord, Directorate of Enforcement versus Subhash Sharma, which
when you were produced before the court.
produced, my lord, on 17/12, but that time is not mentioned in the forwarding, my lord.
As per arrest memo, you were
Shown to have been arrested at 11 a.m. of 17/12/2025.
Yes.
So, my lord, if your lordship
What
will,
is the wrong?
yes, lordship, if your lordship will take up, but he was, though, my lord, it was shown that he was arrested on 17/12, but his initial detention was on 16/12 itself. That is, my lord, clearly indicated in the seizure as well as the FIR. Now, if your lordship will kindly see,
No, for filing FIR, detention is not
my
necessary.
lord, I'll come to that, my lord. Lordship will kindly take up the Director of Enforcement versus Subhash Sharma, that judgment, my lord.
Yes, what do you want to say?
But what I want to submit is this, my lord. The initial detention will start from the time, my lord, when, my lord, his liberty is curtailed.
Yes.
For the purpose of that calculating, computing the 24 hours period.
Yes.
So here, my lord, it is apparent, my lord, that he was likely produced before the magistrate after expired 24 hours from his initial detention.
How?
Because, my lord, he was initially
No,
detained.
suppose the seizing officer makes a request to you.
Yes.
That you cooperate in seizure procedure. We are suspecting that you are carrying contraband and you cooperated. Then whether that can be regarded as an arrest?
Yes. Because as soon as, my lord, his movement becomes restricted.
No, movement becomes restricted on his own.
Not because it is at the instigation of the IO, my lord. Because of the police, my lord, his movement becomes restricted, my lord, because he is unable, and that is why, my lord, he was thereafter, my lord, produced before the magistrate, my lord. Otherwise, he could have, my lord, at least communicated with his family members or somebody else. But because of that, my lord, not only, my lord, his family members or anybody could.
Where were you kept? In
the custody, my lord. All along, my lord, since the items were initially, my lord, seized, he was with the police only, my lord. And it is not known.
What was your date of arrest?
Date of arrest, my lord, 17/12/2025.
Then when were you produced?
On that date, sir.
Whether you have informed the court that the time of arrest has been wrongly mentioned in the.
That, my lord, will be, my lord, available only in the, my lord, first remand order.
No.
I do not have any instruction on that.
But you must be knowing that whether you agitated this before the first, before the proper authority on the, as soon as you got opportunity to disclose.
My lord, first thing is that, my lord, he was not even represented by any counsel. No bail application was moved on that day. So perhaps, my lord, he went unrepresented on the first day of remand. So definitely, my lord, he might have been, my lord, handicapped in, my lord, properly indicating the rights, my lord, which were restricted because of the police action, my lord.
No, if you are not represented, whether any legal aid counsel was given to you.
My lord, that will be apparent from the first remand order, my lord, which I do not have. It will be in the LCR.
Because why I'm putting these questions?
Yes.
The application of Subhash Sharma judgment
Yes.
is dependent upon facts.
Yes.
So, by establishing facts before the court, you have to show that your actual time of detention was something else than what has been stated in the arrest memo. It cannot be, can it be presumed? In the arrest memo, the time of detention in your case has been shown as 11 a.m.
11 a.m.
on 17.
Yes.
Then you have to bring certain facts to the notice of the court that in the night of 16 you were detained in the lockup or in the police.
That will definitely be available in the lower court record, my lord, elsewhere.
Yes,
Because
that you have
at
to.
that point of time, definitely, my lord, his medical will also be done. He will be definitely produced before the medical officer.
Yes.
So all the GD entries will also indicate whether he was all along in the custody of the police.
Yes, that you have to show.
Yes, that will be there in the LCR, madam. LCR is there. Huh?
Okay, what else you want to
Second ground was, my lord.
No, your main submission is that since the FIR indicates that the search was made at a particular time.
Yes.
And search and seizure procedure was done at a particular time. That time may be regarded as that time of your detention.
Yes. Yes.
This may not be applicable in all cases.
Yes. Because no other, my lord, contradictory action followed. Whatever, my lord, action followed was in the line of the, my lord, police action, my lord. In the line, my lord, whatever.
I'm giving you a case.
Yes.
Police got an information that a person is carrying illegal contraband and he is traveling in a train, say Rajdhani Express. Police may immediately arrest him or may request that person that we have certain information, we have to verify the veracity of the information, so we want to make a search. Under that circumstances, arrest may not be always necessary. If you make yourself available for search, that does not mean that you are arrested. If you resist the search by police, which may necessitate the arrest, then question is different. So it is dependent upon facts. Therefore, merely indicating the date and time of seizure would not in all cases simply show that your arrest was also made at that time.
Yes.
That those facts you have to show.
Yes. My lord, because at that particular period, my lord, he was also not released by the police. It's not that, my lord, he was allowed to move freely, my lord. All along, my lord, he was with the police custody. And, my lord, that period, whatever happened, will definitely be reflected in the entries in the official records of the police, my lord. Whether, my lord, he was produced before the medical officer, whether, my lord, he was, my lord, taken to that particular area where, my lord, these things were seized, whether, my lord, whatever happened in that 24 hours duration, my lord, should have been recorded, my lord, in the police records.
When 24 hours should start in your case?
Yes. The moment, my lord, he was detained, and, my lord, the
when
moment,
you were detained?
At 8:20 a.m.
8:20 a.m. That is what I am saying.
Yes.
That in all circumstances of search,
Yes.
detention may not be necessary at the very first instance. It may be necessary only after ascertainment by the police that you are carrying some contraband.
Because, my lord, by 10:3 a.m., they had in the FIR, my lord, they had already come to a conclusion, my lord, that he was carrying suspected cannabis, my lord. In the FIR.
Okay.
In the FIR, my lord, if your lordship will see, it says that at about 10:03 a.m., the recovered articles, including the suspected cannabis ganja, were formally seized from the possession. So by 10, they have already come to a conclusion, my lord, that it was a contraband, my lord. So even if we calculate, even if we assume that the initial period was 10:03 a.m., then also it is, my lord, after an expiry of 24 hours, his arrest was shown 11 a.m. on the next day. So once they come to a, my lord, conclusion that this contraband was, my lord, cannabis or, my lord, ganja, definitely, my lord, there is no possibility that this person will be allowed to go free of, my lord, allowed to be released or allowed to go from the premises of the police station. So that's what I want to submit, my lord.
Okay.
Because the FIR, my lord, was filed on 16/12 itself. And by the time, my lord, the FIR was registered, they already know that he was carrying suspected cannabis. And the police officers are also expected to, my lord, carry the equipments.
Drug detection kit.
Yes.
When they will come to conclusion that it is a suspected cannabis?
As soon as, my lord, they have registered the FIR.
No. After performing
Inventory.
preliminary tests,
Yes.
only then they will come to.
Yes. And that is done at the, my lord, place of occurrence itself.
So that time is relevant.
Yes.
Because you don't know the time when you were produced before the magistrate.
Yes. But anything, my lord, should not cross 10:03 a.m., my lord. It started from 8:20 a.m. and the seizure process ended at 10:03 a.m.
Okay. Okay, make your submissions further.
Yes. So the next ground was, my lord, the non-receipt of the notice under 48 BNSS, my lord. On the last occasion, my lord, the report was called for from the IO as to whether, my lord, the 48 notice was received by the family, my lord, before the person was remanded.
Okay, thereafter.
And the third ground is, my lord, non-compliance.
Suppose family member stays at Delhi.
Yes.
Then how this compliance will be made?
My lord, there is a WT message, my lord. In the record, my lord, there is a WT message which was sent on the very day, my lord, when this person was detained.
Okay. Next, what else is
And the third ground is by the non-compliance of section 50 of NDPS, my lord.
50 how 50 will be applicable? You are carrying
Yes, my lord.
ganja in a separate bag.
Yes, in that regard, my lord, I have placed a latest judgment of the Honorable Supreme Court in a state of Himachal Pradesh versus Surat Singh, which is
What it says?
which is there in the record, my lord.
Oh.
In the file.
What it says?
My lord, if I may summarize, my lord, this judgment says that, my lord, if by a common search, both the person as well as the bag is searched, my lord, then compliance under section 50 is mandatory. If the search is different, body and bag, then it's different. But if by a common search, my lord, both a person and if the bag which he is carrying is done, then, my lord, he will have to be given an option that the search can be done in front of a magistrate or a gazetted officer. Now, in this case, my lord, if your lordship will kindly see the notice, 50 NDPS notice, my lord, it was already a typed copy, my lord. It was already a prepared typed copy, my lord, where only the signature was there. And there are several judgments of the Honorable Supreme Court which says that, my lord, the consent must be in the own handwriting of the accused, in his own handwriting. Now, at that point of time, my lord, how the police would have come to know that this person would not object if the search is done at the place of occurrence itself?
Where is the 50 notice?
50 notice, my lord.
If the person is irritated, then how he that?
It is 50 notice. It is not there in record.
But I have a certificate.
Yes, what you want to show.
My lord, the Honorable Supreme Court has said that the undertaking, the consent which the accused will give, it must be in his own handwriting, my lord. It must be in his own words, my lord. That only, my lord, then only it can be sure that it was actually taken from the accused, my lord. Otherwise, my lord, anybody can prepare anything and take his signature, my lord. That's what has happened, my lord, in this case.
Where is that observation?
That, my lord, I have placed a judgment of Ranjan Kumar Chadha, my lord.
Para?
65. 65. Your lordship has the judgment.
Yes.
However, we propose to put an end to all speculations and debate on this issue of the suspect being apprised by the empowered officer of his right under Section 50 of the NDPS Act to be searched before a gazetted officer or magistrate. We are of the view that even in cases wherein the suspect waives such right by electing to be searched by the empowered officer, such waiver on the part of the suspect should be reduced into writing by the empowered officer. To put it in other words, even if the suspect says that he would not like to be searched before a gazetted officer or magistrate, and he would be fine if his search is undertaken by the empowered officer, the matter should not rest with just an oral statement of the suspect. The suspect should be asked to give it in writing, duly signed by him, in presence of the empowered officer as well as the other officials of the squad, that I was apprised of my right to be searched before a gazetted officer or magistrate in accordance with Section 50 of the NDPS Act. However, I declare on my own free will and volition that I would not like to exercise my right of being searched before a gazetted officer or magistrate, and I may be searched by the empowered officer.
This is what has been typed out.
Yes, but how can at that point of time the officer has a typed copy prepared already, my lord?
No, they can make ready the type copy that in case where any person is waiving his right, then signatures may be obtained.
Yes. But that is will be a disputed question of facts, my lord. But still, my lord, I just want to submit that, my lord, at that particular point of time when an undertaking is to be given by the accused, my lord, obviously, my lord, he will write it in his own language or in his own words, my lord, handwritten. But here, my lord, there is already a typed copy where the IO has even does not have, my lord, if had it been a case where there was two options given, yes or no, nothing is there, my lord. Already the line, the sentence suggests that, my lord, the answer will be in the negative. So probably at that point of time, it may not be so probable, my lord, that.
Yes, notice should have options.
Yes, yes or no,
Yes,
something like that. And the petitioner has completed 177 days, man. That much, man.
Yes.
First ground was 48 hours notice. 48 hours. The law says from his from the time of arrest. So his arrest memo was showing his time of arrest is 11 p.m. 11 a.m.
No, that is his submission that correct time was not shown.
That is his plea, lordship. But how he will prove it, lordship? That has to be proved from his part, lordship, that he was a detained.
He's submitting that Caesar list was prepared at 10:03 a.m. on the previous day. So when Caesar list shows that 10:03 a.m. on the previous day, what happened from the date of time of preparation of Caesar list till formal arrest? Where were they?
First lordship, what happened lordship, he was carrying these articles by train lordship. And during that time lordship, once a person is detained in train lordship, so it will take some time to come to the stations and to return into the stations for that will take some time lordship. And thereafter he was when
No,
he was
preparation
arrested.
of arrest memo may take time. Suppose you prepare arrest memo after some time, but you have to put there the actual time when the arrest was made. So say arrest memo was prepared later on at 6 p.m., but arrest was made in morning in the 10 a.m. Then in the arrest memo you have to show 10 a.m. only. That is saying that though from 10:03,
That was given to him. That arrest memo was given to him, and he was a literate person. He
could have
prove to that
objected.
person that why my arrest timing is at 11. Why that is not written because yesterday night or yesterday I was being arrested, and now the time is so such. But whether he was make that complaint or to make that objection is not that is not there also. Because if he is an illiterate, he do not know how to the languages, then it is different also. But he is a literate person and he has not objected to that question and he has received that process. There is no any question also. So first part or secondly also regarding section 15 notice receipt. Section 15 notice receipt, it has to be in written. So written section 15 notice has been given. Suppose one person is being suppose one person is a illiterate person, so how he will write his own handwriting? Then in that case, lordship, suppose some other person has to be written. So lordship, whether it is in that case also it is written and it's a format has been prepared and that has been his signature was put on that. Because in every way it cannot be written at that time lordship. And person do not know, suppose one person is he do not know English, do not know Hindi, then what will happen lordship? So third question was regarding 48 notice. 48 notice lordship that has also been served lordship because as he is from the other state lordship, so that was WT message was immediately sent. That time is also there lordship. That was immediately sent to the to his father lordship. So all those from this part.
What report has come?
Report has come lordship regarding lordship. They have sent it to the father of the accused person. But they cannot ascertain also whether it was served on that day or not. Also, that cannot be ascertained. Also. So 3 points he has raised. Also.
Good. Mr. S. Das, the learned counsel for the petitioner, also heard Mr. P. S. Laukar, the learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed. This is for the first time you have approached this court.
Yes.
Has been filed under section 483 of BNSS 2023 by the petitioner, namely Sheikh Salabi, who has been detained behind the bars since 16/12/2025. How many days?
177.
Within bracket 177 days. In connection with Bongaigaon GRPS case number 181/2025 under section 20B2C/2026 B2C of the NDPS Act 1985. Where is the FIR?
FIR, my lord, at page number 14, my lord.
The gist of accusation in this case is that on 16/12/2026, one Sanjeev Chaudhary had lodged an FIR before the officer in charge of Bongaigaon GRPS, inter alia, alleging that on 16 December 2025, a routine checking operation was conducted by the personnel of Bongaigaon GRPA, Bongaigaon GRP in the Bongaigaon railway station. Stop. It is alleged in the FIR that at 8:07 a.m., the New Delhi Rajdhani Express within bracket 20505 DN coming from Dibrugarh to New Delhi arrived at platform number 1 of Bongaigaon, New Bongaigaon Junction and stopped. Thereafter, the police team started search of coach number B12, and during the course of such operation, one person was found carrying a trolley bag in a suspicious manner, and after seeing the police party, the said person attempted to flee. Stop. On checking of the said trolley bag, 2 packets wrapped in brown adhesive tapes suspected to contain cannabis within bracket ganja were recovered therefrom. As at about 8:20 a.m., the train was about to depart from the Bongaigaon Junction. The team alighted at platform number 1 along with the accused. These accused are you.
Yes.
Along with the accused within bracket present petitioner. And his thorough search was conducted. Thereafter, it is also stated in the FIR that at 10:03 a.m., the seizure list in respect of the recovered contraband was prepared, and it was found that the total weight of suspected ganja recovered from the petitioner was 26.9 kgs. Stop. Charge sheet has been laid. Thereafter, on the basis of the aforesaid FIR, Bongaigaon GRPS case number 181/25 was registered under section 20B to C of NDPS Act 1985, and investigation was initiated. Ultimately, on completion of the investigation, charge sheet has been laid, and what is the NDPS case?
Well, we had prepared this petition before charge sheet was laid, madam.
And
Case number, case number.
and special within bracket NAR case number 10 within bracket BGN slash 2026 was registered before the Court of Learned Special Judge Bongaigaon. Mr. S. Das, the learned counsel for the petitioner, has submitted that the instant bail application was preferred by the present petitioner during the course of the investigation of the case. However, during the pendency of this bail application, charge sheet has been laid. He submits that the petitioner has approached this court seeking bail mainly on 3 grounds. Firstly, that he was not, firstly, 3 grounds, stop. Learned counsel for the petitioner submits that the first ground on which the petitioner is seeking bail is violation of the fundamental rights of the petitioner under Article 22, Clause 2 of the 2 or 1?
It's 2, madam.
2 of the Constitution of India in not producing him before the magistrate within 24 hours of the time of his arrest. He submits that though the liberty of the petitioner was curtailed after preparation of seizure list at 10:03 a.m. on 16/12/2025, when the seizure list was prepared and when he was suspected of carrying commercial quantity of contraband. However, in the arrest memo prepared by the arresting authority, the date and time of his arrest was shown at 11 a.m. on 17/12/2025. He submits that though the exact time of his production before the magistrate is not known, however, it would certainly be after the time of arrest as indicated in the arrest memo, that is 11 a.m. on 17/12/2025. He submits that as such, the petitioner was not produced before the magistrate after his liberty was curtailed even before ten 0.03 a.m. on 16/12/2025. He submits that failure to show the exact time of arrest in the arrest memo and failure to produce the petitioner before the magistrate within 24 hours of his actual arrest is amounts to violation of his fundamental rights under Article 22 within bracket clause 2 of the Constitution of India. And as such, on that ground alone, he submits that the petitioner is entitled to get bail. In support of his submission, the learned counsel for the petitioner has cited a ruling of the apex court of ruling of the Supreme Court of India in the case of Directorate of Enforcement versus Subhash Sharma, reported in 2025 SCC Online SC 240. He further submits that the second ground which he is emphasizing is that the family members of the petitioner did not receive any notice under section 48 of BNSS intimating in writing the grounds of his arrest before he was remanded to custody, judicial custody, by the magistrate before whom he was produced after his arrest. In support of his submission, he has cited the ruling of the apex court in the case of Vihan Kumar versus State of Haryana, reported in 2025 SCC Online SC 269. He further submits that in the instant case, the petitioner is also claiming bail on the ground of violation of the rights of the petitioner under Section 50 of the NDPS Act 1985. He further submits that when a common search, he submits that though the seized contraband in this case was recovered from the trolley bag which is alleged to have been carried by the present petitioner, however, when a common search, both of person and the bag is made, the compliance of Section 50 of the NDPS Act 1985 is mandatory. He submits that under such circumstances, even for searching the bag which the petitioner was carrying at the time of such procedure, he has to be given an option to be searched before a gazetted officer or a magistrate. And it is only when he consents not to be so searched he consents the waiver of the presence of gazetted officer or magistrate in his own writing there would be compliance of Section 50 of the NDPS Act 1985. Learned counsel for the petitioner submits that in the instant case, the bare perusal of notice under Section 50 of NDPS Act, where the signatures of the present petitioners were obtained, it would reveal that it contained a pre-typed consent form, pre-printed consent form, where the petitioner signature was obtained by the police. He submits that this may not be regarded as compliance of Section 50 of the NDPS Act 1985. He submits that in case of any such search where the suspect waives his right to be searched in presence of a gazetted officer or a magistrate, such waiver should be reduced into writing and has to be duly signed by the accused person, which has not been done in this case, according to learned counsel for the petitioner. In support of his submission, he has cited the ruling of the Apex Court in the case of Ranjan Kumar Chadda versus State of Himachal Pradesh, reported in 2023 SCC Online SC 261262. Learned counsel for the petitioner submits that due to violation of the statutory as well as constitutional rights of the petitioner, he is entitled to get bail in this case. He further submits that there is a discrepancy in the quantity of contraband seized in this case, as in the FIR, the quantity of contraband seized is shown to be 26.9 kg, whereas in the seizure list, the said quantity is indicated as 25.9 kg. Stop. On the other hand, Mr. P.S. Laukar, the learned additional public prosecutor, vehemently opposed the grant of bail to the present petitioner. He submits that the contraband involved in this case is of commercial quantity. Hence, the embargo of Section 37 of the NDPS Act is applicable to this case. I'll continue in chamber and dispose of this case today itself, remaining dictation in chamber.
I'll have this.
Yes.
46, be it fixed on 24th Lordship of this month.
Item number 46. Logo.
Well, item number
46 due to paucity of time. Sobate eke thakibo 26 24 June.
Item number 45, ma'am.
When do
It
you
may
want?
be listed on my 23rd, my lord.
Item number 45 23rd.
Authorized.
My lord, item number 44, my lord, interim order is still to them.
Item number 40
Four.
44 Digulia date diyo. Digulia 17 July 40.
Four.
What is 44? Before vacation due. 25th June. 25th June interim shall continue.
Lordship, item 42, we are on interim. On the last occasion, the DRI council was supposed to file an objection. They have not, provided a copy to us, even if they have filed one. Lordship, the interim may be continued till the next day.
Due to paucity of time could not be taken up, interim shall continue. Next date 25 June.
Deeply overlooked.
May I please your lordship. Lordship, regarding item number 43, my lord, interim is there, my lord.
Interim shall continue 25th June.
My lord, if possible, kindly fix on 18, my lord. Because the petitioner also received summon from the learned court below.
But you are on interim.
Yes, my lord.
Protection is there.
Yes, my lord.
25.
Highly obliged, my lord.